Good afternoon, or good morning, or good evening, depending on where you are logging on today. As we all very well know, we live in unusual times, and last year this event was in person and gathered about 200 people. The downside of the COVID-19 is that this event is taking place online, but the upside is that we have about 300 people registered for the event. And will be joining either today or tomorrow. My name is Lucas Mistelis. I am the chair of the executive board of EFILA and also a professor at Queen Mary University of London, where I look after dispute resolution and particularly focus on investment law and investment arbitration. And it's my great pleasure to welcome you all today at the 6th annual EFILA lecture. Let me say very little about EFILA and then a bit about the conference, and I will then hand over to the chair of the first panel, my dear friend and colleague, Professor Attila Tanzi. EFILA is a think tank that was created about 6 years ago. It's based in Brussels, and the idea of EFILA is to explore the nexus of European law and investment law in all its possible dimensions, both internal and external. A lot has happened in the last 6 years. And of course, what we knew up to perhaps that time is that investment disputes and investment arbitration largely were a matter of party autonomy. Disputes were referred to investment tribunals, either by the power of a concession agreement with an arbitration clause or a submission agreement, or in some cases, other mechanisms. But of course, we also had the entry to investment arbitration via bilateral investment treaties. There has been for about 15 or 16 years an increased debate as to the legitimacy of investment arbitration. And particularly, the discussion has been that in this sort of peak of globalization, perhaps 15 or 20 years ago, non-state actors have become as significant as state actors. And we have seen in the last 10, 15 years an attempt that states want to regain the primary role in lawmaking and initiation of dispute processes. And this is reflected very much in also the idea of a multilateral investment court system that the European Commission has been suggesting originally in the context of TTIP, the Transatlantic Trade and Investment Partnership, which of course is ongoing and perhaps will go for some time. And around that time was the time that EFILA was created. So EFILA is facilitating a debate and is active in that debate with a dispassionate and non-particularly sectorized view. The EFILA members cover law firms, cover arbitrators, third-party funders, financial organizations, and of course, organizations that are involved in disputes as disputing parties. And EFILA doesn't represent any of them. It simply provides a platform and provides a forum in which discussion can take place. Therefore, you will hear in this event today, as in all the EFILA activities, a lot of different voices. No single voice is EFILA, but perhaps collectively, the collective voice is EFILA. And we are going to have representatives of states, representatives of the European Commission, and when we speak of states, we have somebody from Latvia, we have somebody from Gambia, and in the list of attendees, we have representatives from the UK government and other European governments, Czech Republic and Slovak Republic, etc. So the two main events of EFILA are the annual conference, that is what we have today and tomorrow, and the annual EFILA lecture, which takes place in October, typically, and is based in Brussels. The annual conference is a traveling event. It has been in Paris, it has been in London, there has been sort of attempts to bring it to other places, and these attempts will be also discussed in due course for the 7th EFILA conference. What I also would like to mention is that we have a very vibrant younger group that supports EFILA through the Secretariat and of course through the EFILA Journal, the European Investment Law Review, which is a publication that comes from Brill and has had already 5 editions, and it's looking very, very good. So follow the website. They will see a lot of position papers that have been produced under the auspices of EFILA and a lot of other matters. Last year we were debating, as the conference was in London, what will be the future and what will be the reality in 2021. We did not think of COVID, but we're of course thinking very acutely about Brexit. And of course, we have Brexit is now an affair complete, and we will be having during the year a number of roundtables to debate the UK and EU agreement. There's very little about investment protection. There's very little about investment disputes there. But as the negotiations will continue for some time, and as will populate more of the content of that agreement, EFILA will try, together with various other organizations, to organize one or a series of roundtable discussions. Also, perhaps to cover the new EU-China agreement, which again is very thin on the investment dispute settlement chapter, but there will be more coming up, and there will be more negotiated. So the focus today is the renewed significant role of states in investment arbitration. Ever since the Ancestral Working Group 3 started looking at the reform of investment law, of course, as we know from other organizations like UNCTAD and ICSID, all of these processes are state-driven. But somehow states have had the feeling that they're not in the driving seat, or at least they're not in a decision-making capacity when disputes are being organized and conducted. And we have had the defaults of appearance, we had appearance which were not full-hearted, so participating in dispute but without paying for the costs of the arbitration, with or without legal representation, or legal representation starting up at a bit later. And this is not a new phenomenon. I mean, if one looks at older cases like Tradex in Albania, Albania refused to participate, challenging the jurisdiction of the tribunal in Tradex, but once after the jurisdiction has been established, participated on the merits of the phase of the case, they did prevail. And we see that states generally fare quite well on the merits of the disputes. So the focus of the conference is the renewed role of the states in arbitration. And we are going to be presenting that in a number of expert panels. The first panel will be chaired by Professor Attila Tanzi. Then we're going to have today a presentation by Yus Mundi, one of our sponsors. And we're going to be also having a keynote speech to be delivered by Professor Gary Bourne. Tomorrow, and I encourage you to attend both today and tomorrow, we'll be looking at what we call the toolbox or the toolkit of states, what arsenal the states have in arbitration, counterclaims, defenses, different types of defenses, and we will conclude with a panel looking at financial aspects. So I don't want to speak for too long, and I think as per schedule, we are 15 past the hour. It's now my great pleasure to give the floor to Professor Tanzi to introduce his panel. Thank you very much, and I'm looking forward to 2 days of fruitful debate, and please do engage in the chat and the question boxes, and a lot of the questions will be addressed to the panelists and they will be replied to during the session. So, Attila, the floor is yours.
I now unmuted myself. I hope you can hear me. Well, thank you, Lucas, and I thank you and Nikos for the kind invitation. I'm delighted to be moderating in a panel of this standing and on such a compelling topic, one which much has been said, but never enough, I believe. I will make few introductory remarks. They will be general and abstract enough so that they may not in any way predicate my stand on pending cases involving states and their regulatory measures. The theme for our discussion today is inevitably reminiscent, by contrast, of Christoph Scheuer's landmark essay on the waning of the sovereign state. It was a conceptually faithful reflection of a number of photograms of a story which is ever unfolding and is now gaining pace, though amidst storms after calm. That was 1993, shortly after Francis Fukuyama provokingly wrote The End of History. Let's say that in our discussion, we'll be certainly celebrating the fast restart of history since then. The impact of the overwhelming revival of claims of sovereignty by nation states and the accompanying mistrust against internationalization has not spared international investment law and arbitration. Someone has spoken of sovereign backlash against investment arbitration, others of reassertion of control by states over the investment treaty regime. The first and widest sign of this trend pertains to the so-called right to regulate. As quintessential expression of sovereignty, the conceptual complexity of this core issue lies precisely in the basic feature of the body of international investment law today, but on a par with the law on the treatment of aliens, but just as well as with any other branches of international law. Namely, that all international rights and corresponding obligations, by definition, involve a degree of constraint on the sovereignty of the recipient states. That is, those states that joined in the legal process in question by consistent practice and or their consent based on reciprocity and for utilitarian purposes, namely attracting foreign direct investment and promoting and protecting national investors abroad. The matter of fact remains that states usually engage in international lawmaking in their Sunday moods while addressing compliance in their Monday mood. That ties in with the Janus B-faced political and administrative state identity. I mean that the state organs who take part in the international lawmaking process are cognizant of the integrated rights and duty side of the rules they participate in producing, while organs in charge of compliance only seem to see the duty side. Sometimes one has the impression that most of those involved in the debate as to how to best revive the international investment law and arbitration process tend to prioritize the duty side. I suppose this attitude may stand on grounds of economic analysis of the relation between an efficient and predictable investment law and ISDS framework on the one hand, and the foreign direct investment flow on the other. Or simply, it has to do with the revival of the inward-looking dimension of state sovereignty, resisting enhanced internationalization of trade, investment, and movement. The trends towards expanding the protection of host states' sovereign prerogatives with a view to buttressing the protection of public interests of host states are multiple. I will mention just a few. They range from promoting extensive regulatory freedom to exceptionalism under different labels, such as the police powers doctrine of US constitutional law provenance or essential security exceptions increasingly set out in investment agreements. A modulation of the trend in questions is represented by carve-outs, also increasingly to be found in investment agreements, though this is not just a feature of agreements of the latest generation. One may recall Article 1114, Para 1 of the NAFTA with regard to measures addressing environmental concerns. Another route in the same direction of protecting sovereign regulatory prerogatives over foreign investments is the import from the human rights discourse of the principle of proportionality. Now, in an arbitration prospect, the core issue about such approaches and doctrines is whether they imply the qualification of the disputed state measures hampering foreign investment, with special regard to indirect expropriation, as compensatory or not, next to their purported lawfulness. Treaty provisions are increasingly to be found which allow for certain state measures not on the basis of exceptions, but curtailing the actual scope of the primary obligation for states. Concerning indirect expropriation, again, recent agreements either restrictively define the kind of measures falling within its definition or explicitly exclude certain regulatory measures from the scope of the prohibition of measures amounting to indirect expropriation. A similar approach is increasingly followed with regard to FET and the protection of legitimate expectations as part of it. We are witnessing a shift from treaty provisions that would announce FET without qualifications, thus leaving arbitrators with ample margins of interpretation, to provisions spelling out exhaustively the investor's right making up FET. Among different examples, one may refer to Article 8.10 of CETA. In the same direction, one may note the absence of umbrella clauses in a proportionally significant number of new investment agreements. The general trend our discussion today had also manifested itself through narrowing approaches to the definition of investment activities, apart from unilateral national regulatory policy to that effect, which may be subject to arbitral review themselves. The lawfulness of such approaches is increasingly to be found as spelled out in expressed terms in investment agreements, prevailingly adopting the restrictive so-called admission model over the pre-establishment model. The issue is becoming more acute now in relation to the impact of the pandemic on national economies. In that context, various states are increasingly taking measures which are protective of economic sectors which are self-assessed as strategic. In the increased role of the state in investment arbitration is to be taken as aiming at protecting public interest concerns, while in that framework, next to the increased attention to the point at issue in investment agreements and arbitration case law, one should consider significant procedural law evolutions within the arbitration system to the same effect. Suffice to mention the enhancement of transparency, with special regard to the admissibility of amicus curiae briefs and the Mauritius Convention. As flagged by Nikos in the last issue of the European Investment Law and Arbitration Review, which Lucas has just given us indication recently, and most of us know, there are ample margins for the potentials of this procedural institution to be brought to full fruition, but the building blocks appear to be well in place. Next to the more conceptual signs of the trends in question, which are suitable to arbitral interpretation and application, one finds clear indicators against investment arbitration. They can be found in the conventional practice of states and regional intergovernmental organizations. The most recent example of outright discard of investment arbitration is represented by the EU-UK TCA. It provides for no direct effects, thus for no ISDS of any sort, let alone arbitration, as illustrated again by Nikos in a recent post. This element of practice adds to the once anomalous stand taken by Brazil, which has now spilled over to some countries in Africa, or with Mexico, with whom Brazil has reproduced the model at the bilateral level. The EU's stance on intra-European Union investment arbitration may seem to be going against the tide fortifying nation-state sovereignty by rendering the position of member states subservient to supranationalism, except that the European Union is actually promoting a situation in which member states will be eventually largely pulled from international judicative review of the exercise of their sovereignty, while reintroducing judicial control over foreign investors by their domestic courts, and occasionally incidental proceedings before the European Court of Justice may be triggered by domestic judges. I will conclude, and without prejudice to the considerations that we will hear from Gary Bourne shortly on the establishment of a multilateral investment court, I would conclude by expressing the view that one might tend to believe that if the renewed role of the state were to lead to the demise of investment arbitration, states would be still hosting foreign direct investment, and partly by state contracts, and possibly for the most financially robust investments through international contracts. Disputes arising out of such contracts are likely to be litigated before commercial arbitration tribunals. Now, the question one is left with, and I don't mean a rhetorical, but a genuine one, is what would become of the international developments law for the protection of public interest concerns in the international investment law process, aside from the ordre public considerations based on the domestic law of the defendant state. I am referring to the public interest standards that may be vindicated, certainly by the defendant states in any given case, but also by private applicants, as recently in Bilcon versus Canada and Allard versus Barbados. Now, within the time allotted to me, I will stop there, and I will be very pleased to introduce the four outstanding panelists of our first panel. And I will refer to them in alphabetical order. The first is James Boykin. Jim is chair of the Hughes Hubbard Investments Treaty Arbitration Group and a partner in the Arbitration Practice Group at the Washington office. He has a significant record of publications in the field of international arbitration and procedural law. Ilse Dubava is currently legal advisor in the State Chancellery of the Republic of Latvia, devoted to investment treaty disputes. I may recall Isla's doctoral dissertation at the European University Institute revolving around themes that we are discussing today, with special regard to the principle of sustainable development and investment law. Lucian Illy is a senior associate at the Global Commercial Dispute Group, where he acts on both sides of the arbitration pitch, acting both for claimants and defendants. I may add that Lucian is a visiting professor at Toulouse University. Sorry about this. Last but not least is Evgenia Rubinina, an international arbitration lawyer with involvement in a remarkable string of cases throughout more than 10 years. Let me just mention Micula, where she acted for the government of Romania. But Evgenia has represented companies, individuals, and governments alike. You may peruse their impressive bio notes on the program. Now we have 90 minutes allotted to us, and I have taken up, according to schedule, about 17 to 20. We have 50 minutes for the panelist discussion, and we'll leave 25 to 30 minutes for the discussion from the floor. Now, one of the main impact of the new factor that traditionally foreign direct investment exporting countries have been for a long time on the margins of litigation, their companies abroad were involved. Well, they were caught by surprise when receiving the first notifications of arbitration before investment tribunals. And this involved a form of legal cultural surprise, as it were, but also organizational in setting up fully dedicated in-house teams or relying on and interacting with international law firms. I would kindly ask Ilse and Jim for their comments on this issue based on their experience. Ilse, please, you have the floor.
Thank you, Attila, for giving me a floor, and thank you for organizing this event in general, and also for allowing me to be here. It's an honor. And addressing the aspect of building dedicated in-house teams for states, I would like to start with like two reasons how I see it while working for Latvia. Just one note, I'm here in my private capacity and not in any way representing interests or views and points of the Republic of Latvia. And so why there are now more and more in-house teams developed? And my take on that is that, first of all, state is a meeting point of various legal regimes and interests. And as a litigant, it has to balance differing interests of various stakeholders. And it needs to act at all times in wider interests and comply with its policy goals, which usually are exceeding the strict limits of the dispute. And secondly, as Attila already mentioned, there is more caseload. States are more exposed to ISDS claims. They have gained more insight in operation and problem issues of ISDS, investor-state dispute settlement, and that's why they also try to address those problems, either in reforms at the various levels, Energy Charter Treaty, ICSID, ANCITRAL, but also address issues within the state domestically. And that comes from the realization, in order to be successful and effective in defending state interests in these ISDS claims, there is a strong need for standard operating procedures. And that has led states, and I follow the article by Jeremy Sharp in Chiara's Giorgetti book. He excellently addressed the three models and also consulted Latvia at its early stages of establishing its a system how Latvia deals with ISDS claims. And there are essentially three models of states that states choose. It's that there is only outside counsel, and that would usually be for states with a very low caseload, very low ISDS claims load, where it makes no financial or human resources benefit to invest in having a permanent in-house team. But what is the pitfall of that model is that if there is a emergent need to address and comply with all the ISDS deadlines, which usually go beyond what the traditional state deadlines of administrative law request, like 1 month's response and so on, it might be like difficult to get outside counsel involved quickly at the early stages of the dispute. Then there are also the other model is only going in-house, which, for instance, Spain has done. United States, Canada, like United States especially, I believe, gained a lot of experience in the United States Claims Tribunal, and also they are US and Canada are NAFTA states, former NAFTA states, so they have already gained serious experience in that and having a caseload. And the third model, which is also the model followed by the country for which I work, is a hybrid model. So having a dedicated in-house team and also working with outside counsels and experts. And why that model is usually chosen by the states which have a medium caseload of ISDS claims is that, first of all, it is very important to keep the institutional knowledge within the state. Permanently that there is an institution to address who can react quickly, who understands the domestic language, the domestic procedures, knows institutions and can find or locate the people involved who are involved in the dispute as such and can speak also local language. That speeds up the process, saves resources, and is very beneficial for transmitting knowledge within the state, accumulating the knowledge on what these claims are, and also helping, hopefully, address grievances at earlier stage, not allowing the dispute to materialize. And what also the in-house teams in this hybrid model are asked to do is to formulate state defense position in a way that overall fits states' wider policy goals and issues, and also takes into account these wider interests that state needs to balance at all times, at all levels, at whichever dispute or its domestic or international policy. And in-house teams, of course, also help a lot to shorten time periods and finances spent on logistics. For instance, there's inside knowledge of domestic procurement rules, rules on classification of information, rules on obtaining authorization to act. For instance, in the case of Latvia, we have Cabinet of Ministers, which is the ultimate decision maker, including on decisions on what will be the amount of finances allocated to the case. And we also monitor outside counsel's work and costs and develop like a kind of a knowledge on how to attract and what put in contract with outside experts and counsel. So I believe for states with medium size of caseload, it's very beneficial to designate certain individuals in the state which work there permanently, have knowledge, and have this kind of expertise. That would be on my side it.
Thank you very, very much, Ilse. There has been a fair degree of flexibility for the kickoff question time-wise, but if I have to look at the numbers, I may kindly ask a panelist to confine their intervention to 3 minutes so that we can have the chance to have repeat questions and interventions. Jim, what is your reaction to this issue? What is your view? You have to unmute yourself, Jim.
Thank you, Attila. It's embarrassing. After 9 months, you would think I would remember to unmute myself. 9 months of experience of conducting business this way. No, it was very interesting to hear Ilse describe the 3 models. I know from the perspective of being in the United States that the United States has always followed the second model, and so has Canada. And but that you know, Canada does in some instances work with outside counsel. We represented Canada in a state-to-state dispute against the United States. But in investor state arbitration, Canada is very much in what Ilse described as the second model, where they use in-house resources only, and they're quite good. And so is the United States. And I think Ilse correctly traced that back to the experience with the Iran U.S. Claims Tribunal under the Algiers Accords. That has to be the reason that they had the competence in-house and the confidence to handle all of the cases. And you know, I think that the idea, the willingness to enter the dispute resolution arrangement in the Algiers Accords traces back. There was institutional memory within the State Department to the claims commissions of the early 20th century. But so in that sense, with our topic, the renewed role of states, from the United States perspective, you know, handling the cases itself is not really a renewed role. It's how the United States has been doing business for a very, very long time. But in my experience, I think what we're seeing is more a shift to the model that Ilse described, a hybrid model, and where states are trying to preserve institutional memory, consistency, and overall, I think, budget control. They do see value for outside counsel. I think that the perception of the role that outside counsel can play differs depending on which state you're dealing with, and that some states have a more sophisticated way appreciation for how they can valuably integrate outside counsel into their management of the cases, whereas other states are still trying to figure out that balance. So that would be my reaction. And if I could lateral the question back to Ilse, it was just something that I've always wondered. And from Latvia's perspective, recognizing it may differ from state to state, but what is it? What role do you see outside counsel play? What value do outside counsel and experts add to your process? What do you look for?
Okay, what we look for is, of course, the in-depth expertise in the very specific question that is at the core of that specific dispute. For instance, if that's a banking dispute, we would search a counsel who has expertise more or less in the banking dispute. If it's about construction, then it will be someone we will search in procurement who would have like experience and knowledge of the relevant regulations, which we don't have necessarily. So I think that is one of the aspects. And of course, Latvia has now the specific system for around 5 years. We also search for someone who is ready to share the methods on how to effectively ensure the state representation in ISDS cases, who are willing to also train state officials and share their knowledge, which is not necessarily about the case.
Well, thank you very much to Jim and Ilse for your interventions and also for your quick pas de deux. Now, it is fair to say that the phenomenon we are looking at today has had a significant impact on the applicable law, and this may increasingly bring about problems of compatibility and coordination between different sources of law, between different branches of public international law, between public international law, domestic law, and European Union law. I may kindly address the question to Evgenia and Lucian. Evgenia Rubinina. Evgenia, you have the floor, please.
Sure. So one of the main areas in which states can influence investment treaty arbitration is actually through amending their own domestic law. And of course, the starting point in analysis and investment treaty arbitration is that liability is typically established as a matter of public international law under customary international law and under the LC's articles on state responsibility. However, one should not forget that there's actually quite great scope for investment treaty tribunals to apply domestic law of the host state in its decision making, and also sometimes of the state of the investor and sometimes even of third states. And the starting point here is Article 42 of the ICSID Convention for ICSID arbitrations. And Article 42 of the ICSID Convention provides that the tribunal shall decide a dispute in accordance with such rules of law as may be agreed by the parties. And in the absence of such an agreement, the tribunal shall apply the law of the contracting state party to the dispute, including its rules on the conflict of laws, and such rules of international law as may be applicable. Now, surprisingly few investment treaties actually contain an applicable law clause. Some of them do, and usually they're formulated along the lines of the tribunal shall reach its decision in accordance with the provisions of the treaty, the law of the host state, and general principles and rules of international law. Formulations might differ, but it's something along these lines. And it does give tribunals a broad latitude to choose applicable law, but it probably cannot be characterized as a choice of law provision per se. In the words of Zachary Douglas, this is simply a confirmation of the tribunal's power to apply different legal rules from different legal sources to different issues in dispute. So with this in mind, there's a number of ways, a number of scenarios in which the law of host states, the law of the states of the investor can come into play in an investment treaty dispute. Number one is establishing the nationality of an investor and things like rules on dual nationality. This is quite a relevant issue. Rules on the nationality of corporates, state of incorporation, siège social, etc. Establishing the existence of property rights and the existence of a protected investment will often very much depend on the law of the host state. And the big one here is legality or illegality of an investment. Many BITs stipulate that only investments that are made in accordance with local law can benefit from protection under a treaty. And for treaties that don't contain such a provision, there's a debate in jurisprudence and in commentary as to whether such a legality requirement can and should be implied. And this is, from my perspective, the area where there could potentially be a greater application of domestic law. However, at the same time, there has to be a reasonable balance. One shouldn't use the legality requirements in investment treaties to import technicalities, trivial requirements of domestic law in order to let the state off the hook and declare that investment was made illegally.
Well, thank you very much, Evgenia. Lucian, what is your take on this?
Thank you so much, Professor Attila, for your kind introduction, and to the EFILA members for inviting me to be part of such outstanding panel. What I would like to add, and indeed I agree with Evgenia that we have seen a trend, yes, that states are trying very often to rely on their national domestic law in order to escape liability or to add formalities or technicalities in order to in fine escape liability. But what I would like to remind is that the practice shows that in majority of cases, there was no choice of law provision in the arbitration initiated under a BIT. Therefore, in such cases, it's crucial for the determination of the applicable law on what are the arbitration rules that are applying at. Under various arbitration rules, one major difference exists between the ICSI system and the other fora available to the investors. And here it's important because there is a dual application of law which applies for ICSI system. It is the rule of the law of the host state and the international law. In other words, the role of the international law in investment treaty arbitration is essential, as it will always be the law governing the interpretation and the application of the treaty, providing the basis of the arbitration, irrespective of whether or not this treaty refers to international law as the law applicable to the merits of the dispute. Now, a second point that I would like to make is what about the interaction between EU law and international law? Because it's about the compatibility, as Professor Attila read in his introduction. There is no surprise anymore for investment tribunals called to resolve intra-EU disputes to see the European Commission showing up at their doorsteps to try to convince them to decline jurisdiction through amicus curiae submissions. Although the range of such arguments remain wide enough depending on the circumstances of the case and the underlying investment and treaty that is applying to a specific case, one core argument has always been that EU law prevails in relations between member states and overrides all international law commitments that member states and EU itself, in case of the ECT, for instance, have entered into. Now, when we look back and about this stance, we have seen that the Commission had some limited success by raising such an argument. For instance, in Electrabel, the tribunal concluded that EU law would prevail over the ECT in case of any material inconsistency. However, other times, such an argument was simply dismissed. If we are looking to the tribunal in RREEF infrastructure, the tribunal concluded that EU law does not and cannot trump public international law, even where this would be the source of a possible detriment to the EU law. Now, in short, and I will conclude with this remark, as regards interaction between EU law and international law, many tribunals simply dispose the matter by pointing out that there was no relevant material inconsistency, no conflict, no need to rule on matters of EU law, no incompatibility of obligations under different treaties, and or nothing that could not be resolved by an harmonious interpretation. Thank you.
Well, thank you, Lucian. Well, I suppose this topic brings in the issue of the relevance of constitutional law principles that may be both pertaining to domestic law or supranational law, and you, Lucian, has just spotted the issue. It would be interesting to hear a quick chip-in intervention by reaction by Ilse and Jim, if you felt like it. Ilse, would you like to express views on this, on the constitutional aspects?
The constitutional aspect here, and I will just touch upon, and again, not representing the point of view of the Republic of Latvia, but my own, is on limits of applicable law, which has become now also an issue which is addressed in multiple reform processes that investment regime is undergoing. And then I want to recall one of my supervisors, Pierre-Marie Dupuy, back when I was at school, is there is no fragmentation of international law, but there is fragmentation of knowledge of international law. And all this ACMEA judgment issue and intra-EU BIT issue and EU Commission as an amicus and state positions and very consistent arbitral practice regarding that it's probably not relevant, kind of brings me back to that knowledge of no fragmentation of EU law, but fragmentation of knowledge. And the argument I want to make, is it not the ACMEA judgment and its conclusions, is it not the genuine conflict of norms situation in ISDS cases? And in that case, also those Vienna Convention law of treaties principles on which norms to take into account and which are on the same subject matter in order to enlighten and read the norm, are they not relevant also here? And I think it seems to me that this aspect is disregarded. And also what is disregarded by sometimes arbitral tribunals that, for instance, in interpreting ACMEA judgment, what needs to be also taken into account that the Court of Justice of the European Union is the autonomous interpreter of EU law, and that there was no referral mechanism by arbitral tribunals to ask questions on autonomous interpretation and application of EU law is the essence of ACMEA judgment and its decision. And I think that repeats also in arbitral tribunals' approach, how they approach ACMEA decision and how they try to interpret it. And one just observation that the same subject matter, for which is an element to be addressed when conflict of norms is analyzed, has now become absolutely a political issue that is polarizing EU member states and the Commission on one side and investment community on the other side. And was it the correct way to go? Is there something like missed from the legal arguments? I think some legal arguments are missed in a way to address this issue legally, but it has become a very politicized issue. That's my intervention.
Thank you, Ilse, for your articulated reaction. Well, thank you very much. And for obvious reasons, I already mentioned I'm not going to take part in these exchanges, but I may only emphasize the amazing thinness and ambiguity that comes out from Article 31.3c between the concept of interpretation and that of application, which may lead different tribunals to significantly different interpretations. I mean, it was probably a rule that back in 1969, the drafters would have not imagined how controversial it could become and how important at the same time it would be. See. Now, one of the trends that the phenomenon we are discussing today has brought about is a consistent practice of a trend towards termination of treaties and withdrawals from multilateral investment protection treaties. Now, problems may arise, particularly when the notice of termination is not clear about whether it relies on the treaty provision on the point or whether it intends to pursue the extinction of the treaty by mutual consent under Article 54 of the Vienna Convention. And I have particularly in mind the legal consequences of the first choice, therefore bring about the so-called sunset clause. Evgenia and Lucian, would you like to comment on this? Evgenia, please.
Sure. So one further area where states obviously have a greater opportunity to tilt the playing field in their favor is the termination of treaties, not something that is open to investors at all. And this can come to be in multiple ways. It can come across as a termination of treaties, either by mutual consent, as Professor Tanzi mentioned, or in accordance with the provision of a BIT, which often provide for the possibility of terminating a treaty at certain specified intervals in time. Or often recently we've seen treaties terminated due to their renegotiation and their replacement by different treaties, such as CETA, for example. And obviously on everybody's mind is the recent termination of intra-EU BITs. And for us UK-based lawyers with UK clients, a very live issue is what happens to the UK's BITs with EU member states. We all noted, maybe with some relief, that nothing was mentioned about the status of about 12 BITs between the UK and EU member states in the investment in the EU-UK Trade and Cooperation Agreement that we all saw over Christmas. So we'll see what that means for the status of the UK's BITs with EU member states. And other examples of recent mass BIT terminations include terminations of BITs by Indonesia, South Africa, and India. Very much the effect of the BIT's termination will depend on the chosen method for the termination. And it does seem that, and also on the status of the dispute, what the BIT is invoked. It seems that the strongest position of the investor is when an actual dispute has already been commenced. It is difficult for a state to unilaterally withdraw consent to arbitration when an arbitration is already pending. For example, Article 25.1 of the ICSID Convention expressly precludes that, and this would also be contrary to customary international law, as per, for example, the Nicaragua case in the ICJ. There's more of an open question of what happens to future claims and what happens, for example, when a trigger letter, a notice of dispute has been sent to the state, but no arbitration is underway yet. And in situations when investment treaties are terminated in such a way as to override sunset clauses in these treaties, as has been done with intra-EU BITs, arguments could be made that investors have accrued rights under these treaties that cannot be abrogated. There's also been suggestions and commentary by Laura Hallinan, for example, that such termination would amount to bad faith under international law. So far, this is an untested question in jurisprudence. It would be interesting to see how tribunals react to that. And one also potential avenue for challenge would be under the domestic law of the whole state, of the states of nationality of the investors, who could, depending on what the domestic law says, bring claims in the local courts against their states of nationality for depriving them of the right to bring an investment treaty claim against another state. In a situation where a softer approach is taken to the termination of a BIT, then and the sunset clause is not terminated, it seems that investors can still be able to bring claims during the sunset period. And there's also an in-between approach that has recently emerged in treaty practice, where the states parties do not completely abrogate sunset clauses, but provide for shortened sunset clauses in comparison with what the original treaty provided. For example, CETA overrides BITs between Canada and EU member states, and it's not completely overrides the sunset clauses in these treaties, but abbreviates them to 3 years. And some states appear so concerned about the limits on their sovereignty imposed by sunset clauses that new BITs that they are concluding include no survival provisions at all. And an example of that is the 2016 Morocco-Nigeria BIT, but that still appears to be more of an exception, hopefully, because it does create a situation for an investor where an investor cannot rely on the existence of a treaty that can be terminated at any moment without any guarantees for it.
Well, thank you very much, Evgenia, for that comprehensive tour d'horizon of all possible problems existing and yet to come. That was very interesting. Lucian, how would you react to these observations?
Thank you so much, Professor Attila. I would like to add two comments on this respect. One is about the liability, I would say, and the second one is about the consequences. The fate of the intra-EU BITs continues to divide member states, as we have seen it. Yeah, the termination agreement was signed only by a large majority, but not all member states. Now, the question which arises is whether the member states have an obligation to cooperate and implement the termination agreement as per the Commission's position, which is much stricter than some of the member states, and if yes, what are the consequences in terms of international liability for the member states when complying with the EU, but undermining their international obligations at the same time? And here it's about the issue of attribution that I will come back later on when we're going to address this topic. But for now, 2 points appear evident. First, it can be argued that the termination agreement goes beyond what is necessary to remedy the incompatibility. In Acmea, the ECJ was only concerned with the compatibility of the arbitration provision itself of the intra-EU BITs and said nothing about the substantive protection standards, even, of course, if it is hard to see the relevance of having a substantive protection without an ISDS provision. Second, whether the termination of the sunset clauses is effective as a matter of international law and whether the retroactivity of the termination agreement is in conformity with the rule of law and general principle of international law. We don't have to forget that the termination agreement terminated the remaining BITs and sunset clauses as per Article 1 and 2 in lieu of the standard classical two-step approach, modification and termination, as laid and set forth under Article 71b of the Vienna Convention. Now, this leads me to the second point, which is intra-EU investment arbitration really over? Of course, from the perspective of the European Commission, yes, there will be no longer be a parallel system of overlapping with single market rules. Now, I will be more cautious on that because we don't know yet, as Evgenia just stated. And there might be creative solutions to overcome or circumvent such issues. It is true that the disputes concerning the interpretation of the termination agreement must be resolved by the ECJ because it contains in Article 14 a special agreement under Article 273 of the TFEU. However, the effect of the termination agreement on the jurisdictional competence of the investment tribunals will de facto also remain subject to the standard principle of competence. Seized of a claim, investment tribunals will have to decide based on their interpretation of whether the termination agreement properly terminated the BITs and sunset clauses and as of when. For instance, it may be that investors will seek to argue whether in reliance of concept of legitimate expectations or the doctrine of acquired rights or otherwise, that a sunset clause cannot be retroactively abolished by contracting parties to the applicable intra-EU BIT in respect of investment that were made prior the termination of such agreement. Now, of course, it may play into account for the damages part, but this is not the issue here. Now, if an investor succeeds in a claim under an intra-EU BIT, the obvious issue is the enforcement. And here, what I would like to remind is that enforcement can take over the world. Enforcement is not only in intra-EU countries. It can go outside intra-EU countries, and therefore, there is no issue anymore of compatibility of international law and EU law. Alternatively, investors also may consider to structure their investments through a vehicle which is incorporated outside the EU. This is also a solution to deal with the compatibility issues. Now, the last point that I'd like to make is it will be interesting to see if and how investors and states make use of the structured dialogue to settle pending cases as forth in Article 9 of the termination agreement. Now, my answer is, in short, it will be worth watching the next steps of investors, states, arbitral tribunals in intra-EU investment disputes in order to have the right and certain answer of whether intra-EU BITs are really over. Thank you.
Well, thank you very much. I understand there is much to keeping a watch eye, future practice and case law. One aspect germane to the enhanced role of states is to do with their activism in the international financial and investment arena. States operate on international markets directly or through state-owned enterprises. Such variations and modulations may prompt issues of attribution of international wrongfulness for defendant states, or may involve states as claimants, particularly in a contract claim context. I would like to ask Lucian and Evgenia again for their views on this, and if they are brief, it would be good to hear comments, short comments from Ilse and Jim. Lucian, do you need to recover, and shall I give the floor to Evgenia, or you?
I'm happy to give Lucian the opportunity to recover.
Yes, indeed. The first two were for Evgenia, and the last two for me, indeed. Thank you, Evgenia. Now, I will come back about the points that I just made about the attribution, i.e., what are the consequences in terms of international liability for a member state when seeking to comply with EU law but undermining their international obligation. In other words, whether the member state had a real discretion to act otherwise in accordance with other international obligations. Now, when we look to the international agreement, can we really say that the member states have acted freely and without any political and or legal constraints, such as facing infringement proceedings in this process? Or rather, is it correct to say that the member state acted under the normative control of the EU by implementing simply the EU agenda? Now, as you may be aware, it exists a special rule of attribution according to which the conduct of the EU member states implementing binding acts of the EU is attributable to the EU itself and not to the member states who are exonerated from any liability. I would like to raise 2 points here. The European Commission itself argued in favor of such normative control in the course of the ILC work on responsibility of international organizations. In particular, in its comments and observations submitted in 2011, the European Commission stated, and I quote, EU member states have transferred competencies on a range of subject matter to the European Union. The member states are obliged to carry out binding decisions and policies adopted by the EU according to the EU's internal rules. This requires special rules of attribution and responsibility in cases where EU member states are in fact only implementing binding rules of international organization. In other words, the EU exercises normative control of the member states who then act as union agents rather than on their own account when implementing union law. Secondly, a normative control argument also has been reasoned and put forward by WTO panels. In particular, the WTO panel in European Communities, protections of trademarks and geographical indications for agriculture products and foodstuff, accepted that the community laws are generally not executed through authorities at the community level, but rather through recourse of authorities in and by member states. In such situations, the member states are acting de facto as organs of the community and will not be liable under international law. Now, when I read those 2 points, I looked in the investment arbitration jurisprudence, and I could find only one case where a tribunal in Electrabel against Hungary touched bases on such normative control argument under Article 6 of the ILC Articles on State Liability, Responsibility. And the tribunal in that case considered that Hungary is not and was not legally responsible for acts by the European Commission, such as implementing its decision that required Hungary under EU law to terminate the disputed PPA. Now, based on this normative control argument, one could anticipate that some respondent states may try to argue that, absent to any legal discretion when they implemented the EU position as regards ACMEA and the termination agreement, this should be a relevant factor when considering liability and attribution by an investment tribunal. Thank you.
Well, thank you, Lucian. I forgot that council can stand on their feet or keep the floor and virtually for long. We have quite an endurance. So, Evgenia, please.
Yes, before I turn to my comments, I was going to say that there's a different side of the same issue, which will probably be tested in the Gazprom case against the European Commission, of who is the proper respondent in a case where a claim is brought against the European Commission. So we'll see that. What I was going to talk about is another aspect of states' more active involvement in international arbitration, which is states acting as claimants effectively through their state entities in investment treaty cases. And Professor Zanzi mentioned in his introductory remarks that states enter into BITs in their Sunday mood, and then, you know, it's Monday when the consequences hit them. And here, perhaps, where state-owned entities are acting as claimants, is still more of a Sunday mood for them potentially. And when preparing for this conference, I actually discovered quite a big variety of claimants in a variety of industry sectors and from all sorts of parts of the world that are state-owned entities bringing investment treaty claims. Perhaps most familiar to EFILA attendees would be the Vattenfall claim against Germany, which is a long-running claim by a state-owned Swedish company in relation to Germany's decision to phase out nuclear energy. But, you know, there's also been claims by Airbus against Poland, the State General Reserve Fund of Oman, which is a sovereign wealth fund, several years ago brought a claim against Bulgaria. And, you know, close to the part of the world where I'm originally from, several Ukrainian state-owned entities, Ukrenergo and most recently Energoprom, have pursued claims against the Russian Federation in connection with the annexation of Crimea. And some claims have actually been brought by state organs and regional subdivisions. One example is the claim of the Kaliningrad region against Lithuania, and the Republic of Tatarstan has pursued an investment treaty claim against Ukraine, arising out of similar events to the Tatneft against Ukraine claim. So this raises a number of both interesting legal and policy issues. The legal issue is whether an investment treaty claim by a state-owned entity effectively amounts to a state-state dispute and is therefore outside the scope of jurisdiction of an investment treaty tribunal. And this argument was made by Ukraine in the Tatarstan arbitration, where Ukraine also challenged the jurisdictional award before the Cour d'appel in Paris, at the seat of arbitration, and it argued that because it was effectively a state-state dispute, the tribunal lacked jurisdiction over it, and the French court declined this argument and upheld the award. And there's a slight twist on that for ICSID arbitrations. There is an argument that there's a so-called Brockes-Test, whereby state-owned or entity claims against states are only permissible unless the state-owned entity was acting as an agent for the government or discharging an essentially government function. And this arises out of comments made by one of the drafters of the ICSID Convention, Aaron Brockes, at a 1972 Hague Academy International Law lecture. However, the slight problem with that is that the actual text of Article 25 of the ICSID Convention contains no mention of state-owned entities. And most BITs are agnostic, again, as to whether state-owned entities are covered by the scope of a protected investor. And most cases, actually all cases where the Brockes test was raised, the objection was unsuccessful. So it appears that these arguments are not going to be successful, at least in jurisprudence. But there's also a very interesting policy issue here. There's effectively a dual role for these state-owned entities. And one would hope that maybe states whose state-owned entities are actively involved in investing abroad and are appearing as claimants in investment treaty arbitrations might take a more balanced view of investment treaties and see more of the benefits that these treaties can accord to their entities, be more alive to them, and not take a very strict black and white view of such treaties. On the other hand, we've seen instances where states may put pressure on their state-owned entities to take certain positions in these arbitrations and even to withdraw claims, such that this would be in line with this state's official approach to investment treaty arbitration. For example, it was reported in 2018 that Airbus withdrew an investment treaty claim against Poland under the Netherlands-Poland BIT, which arose out of a cancelled helicopter deal. And reportedly, the reason for the withdrawal of the claim was the then recent ruling in the Acme case. And instead, Airbus was reported to be seeking compensation in Polish courts. So this is an interesting policy area where states are again asserting themselves and not appearing just as victims in investment treaty arbitration.
Well, thank you very much, Evgeny. I have planned and coordinated with you quite a number of questions on which I was very curious to hear your views. I may not be able to deliver all them unless you have a particular keenness, Jim and Ilse, to chip in on this particular issue. I would pass on the next one, but if you want to give a quick comment on this point. All right, thank you, Jim. What about yourself, Ilse? Could we pass, or you want to make a quick comment on this point?
Can I just make one very quick point, which is not very elaborate, but
please.
I'm probably a little bit off, but regarding state-owned entities, I'm wondering why like investment community bothers about state ownership, but sometimes in non-state owned, or we don't know who owns a company. It's not that important who owns a company. There are affiliates, there are schemes, vertical, horizontal integration of companies that we don't know whose actual owner is. But if it's known that the owner, but not the controller necessarily, is a state, it somehow becomes a different issue. Just this kind of highlight, and that's it.
Thank you very much, Ilse, also for your brevity. My next question bears on the fact that the enhanced role of states in investment arbitration goes hand in hand, or to a large extent is accompanied by the increased relevance of the investor's conduct. I mean, scrutinizing the investor's conduct with regard to their investment making or carrying out the investment. This brings into question the clean hands doctrine, the very disputed clean hands doctrines as to its state customary status, and issues of corruption. Very delicate issue, and that from a procedural standpoint brings into question the appropriateness of dealing with these questions as a matter of admissibility separately or jointly with the merits of the case. This has obvious technical procedural connotations, but at the same time strong policy connotations. So I may kindly ask Jim, if you wish to take the lead on the reaction to this point. Would you please, Jim?
I'd be happy to, Attila. Thank you. You've teed up the issue correctly. There are policy and procedural dimensions to whether an assertion that there has been corruption by the state amounts to a defense on admissibility or jurisdiction, or whether it's a defense on the merits. I think, as lawyers approaching any case neutrally and with a view to fairness and objectivity, there is a natural disinclination to want to allow a state to assert corruption as a way of avoiding a legitimate claim, simply because it takes two to tango. And so there is some, I think, reticence to sort of view it as admissibility, raising issues of admissibility and jurisdiction. That observation, of course, is always subject to the text of the treaty. There are some treaties that have clear language that, corruption at the inception of the investment would necessarily implicate the tribunal's jurisdiction or the admissibility of the claim. But you also note that I said at the inception. I think another relevant fact that has to be analyzed is, was this a legitimate investment when it started, proceeded for years, and then at some point along in the course of the investment, there was corruption? Is that fact that corruption occurred in the course of the investment and not its inception, does that implicate admissibility and jurisdiction? Or is that more tightly connected to the merits? I think you can see a case where, particularly in a claim for legitimate expectations, that allegations of corruption would be very germane to whether the investor's expectations were in fact legitimate. If those were procured, the expectations were procured in part by a bribe, they would not be legitimate. And that is sort of the merits or better framework in which to analyze that type of question, particularly if it did not occur at the inception of the investment. Expropriation, does the state's enforcement of, policing corruption that it discovers constitute an expropriation? That's another sort of question you could see more framed as merits. And I think the question of corruption on the merits can also come up in the context of full protection and security. In one case in which I was involved, my client had detected corruption on the part of his business partner, who was affiliated with presidents and high members of high level of the government. He reported it, and nobody did anything about it. And so, what is a state's duty to respond to corruption allegations that are actually raised by the investor, and when they don't, and can that constitute a substantive breach? It's not always a defense to a treaty case. It can also form a part of the investor's substantive case. And in this case, the investor, his business partner, had embezzled, and a lot of that money went back to high-level officials. So I think, like many things you want to in the law, you want to avoid overly broad answers that generalize. I think in this case, it's always good to start with the treaty. What does it say in terms of the legality requirements? You also want to look at, when did this alleged corruption occur? I think there are significant, strong arguments can be made that it raises jurisdictional admissibility questions when, but for the corruption, the investment might not ever have occurred. But when there's corruption along the lines during the course of the lifetime of the investment, it may be the case that it's better to look at those. It's very hard to potentially disentangle that from the merits. So there's not a one-size-fits-all answer to this very thorny question. And but I sort of kind of surveyed some high-level questions I would ask going into it.
Well, thank you very much. I suppose I will not be conflicted out by concurring with your wisdom in tackling this very delicate issue. Well, thank you very much, Jim. Our time is getting to a close. I mean, we want to be quick if we want to cover some more ground and not take time away from the audience. But Evgenia, would you like to comment on this issue, please?
Just one point. Jim was absolutely right to say it takes two to tango, and we've seen trends where certain states repeatedly make allegations of corruption, raise the corruption defense. Sort of that becomes their modus operandi. Pretty much sure that in every case they will raise it, and it's in my view it's just becoming increasingly less convincing to tribunals when the same states repeatedly makes allegations of corruption. and these allegations are not accompanied by prosecutions of that state's officials, it really decreases the convincingness of such arguments and raises policy questions as to whether a state is using its structural governance defects as an escape from its investment treaty liability.
Well, thank you very much. Evgenia, any request for the floor from Ilse or Lucian on this?
If I may, yes, I would like just to add 2 points very briefly. First is that the standard of proof which is required, particularly in investment arbitration, is very, very high. Yes, I think there is a common base on that. Now, the caveat that I would like to make is to be sure that the parties and the tribunal are dealing properly during the arbitration process on all the grounds which are raised in respect of corruption, because we have seen, and I have in mind two recent cases, the Court of Appeal of Paris and Hague Court of Appeal, where the courts, the national courts, set aside after awards because, and I quote, the tribunal applied a too strict standard of proof requiring direct evidence, despite certain red flags. Now, I think we have to do a proper balance there and not take it as granted. This is the first point. The second point is for investors about the legality of their investments. I've been surprised to read in one exit case, Anderson against Costa Rica, that the tribunal found and dismissed the case as on jurisdictional grounds because the original investors, which invested in good faith, have been prevented to have a legitimate investment because the original investor, which relied on, was fraudulent. Therefore, when you are entering into an investment with a partner, or you are acquiring an investment which has been already started by someone else, be sure and do the due diligence properly, because it can come back on you. Because in that particular instance, the tribunal considered that even though the subsequent investor was not aware about the legality of the investment, the operation and the project itself overall was tainted by fraud, and therefore they dismissed the case on jurisdictional grounds. This is the second point that I just wanted to raise as a warning for investors.
Thank you very much. It was a good point, Lucian. If Ilse will not require the floor,
I would like to.
Would you? Well, please, you have the floor.
But Jim, if you want to go first, please do that.
No.
Okay, I have like three. I will try to be as brief as possible, but three elements I would like to mention. Unlike Evgenia's observation, mine was that actually investors are constantly bringing up corruption allegations, and that seems to me that usually they serve to make sure for administrative institutions who registers a case to make sure that they are actually treaty claims. If there's an allegation of corruption included in the notification of a dispute. Secondly, my question is whether arbitral tribunals, as they stand at the moment, with the ethical rules, that they are party appointment, that they can double hat, and the limited amounts of tools for like investigation, are they actually fit to address corruption claims? And then we also see that the two cases that come in mind, in one case, Metaltech versus Uzbekistan, arbitrators who decided there is a proof of corruption, but on circumstantial evidence, but there was also admission of red flags by one of the parties. But for instance, I would like to draw your attention to Belokon versus Kyrgyzstan case. It was on money laundering, and the arbitrators were not convinced that there is an issue of corruption, money laundering, but then the award was annulled because the Paris court, in which the annulment took place, was not convinced that this issue was properly addressed, and then it resulted in the annulment. And then just the question, if I believe there is a ground for these reform processes to move forward and to see if there is a wider need and constitutional aspect how to reform the system, because I believe the existing model of party selected arbitrators is not the best way to address issues of this public. It's basically issue of international public policy. And the third element is that also stems from the Belokon versus Kyrgyzstan case in Paris challenge. What happened that, for instance, how for states to address the issue if there is a pre-trial investigation, and in most states, at least that's my belief, that materials are not given to other party until the case on corruption investigation is submitted to the court, when the accused one also gets full materials. And this aspect, for instance, where state tried to prove in Paris court in Belokon versus Kyrgyzstan, was a reason why some parts of evidence on corruption were actually removed from the case file, because Mr. Belokon had not gained access to those materials. And this issue was also playing a pretty significant role in not an investment case directly, but we had a bank president of Latvian bank who was accused of corruption. There were domestic investigation on that ongoing. He was also the board member of the European Central Bank, which then had a dispute with Latvia. And there also Latvian investigators could not give evidence at that time to the European Central Bank and European Court of Justice, because it was in pre-trial stage. And that was widely publicized, why Latvia failed in that case, European Court of Justice did not agree with Latvian measures imposed on the individual. So there is an issue of domestic law, appliance, justice, investigation in corruption, and which comes up, I think, in investment arbitrations. And I doubt there is at the moment a good way how to exit the situation and ensure proper fairness in those matters. Thank you.
Thank you, Ilse. I'm now speaking to Nikos. Since I don't see any questions on the window on questions, I assume I can go on with extracting views from my panelists. And if that is the case, the next issue I would like very much to hear views is another one of policy in a way. Last year, the keynote speak by Meg Kinnear was to do with conciliation, and it upon mediation. Now, I would like to hear your views on the feasibility and difficulties particularly for disputing states and their officials to come to a settlement agreement. And precisely, Ilse, this is an issue I would like you to express your views in the first place, if you don't mind.
I definitely don't, and thank you for giving me a floor again. On alternative dispute resolution to arbitration, which was initially already alternative to a dispute settlement mechanisms and states, I believe what the take of this many states seems to be, and what is my understanding, that settlement, which usually is even more confidential than the current arbitration mechanism, it has the same legitimacy concerns as the investment arbitration, namely, who are decision makers, either accessed by third-party stakeholders, also to give their input if their interests are affected. And what is also the problem, I think, which needs to be taken into account when settling without a legal settlement, which would be arbitral award or a judicial award, is that investors, at least when they notify the dispute, which is not yet materialized fully, sometimes are extremely scarce regarding information. For instance, on their corporate structure, like who they are, or also on the damages done. And there are, I guess, strategic reasons for that. But for instance, if there is a settlement proposal, like for instance, mediation or negotiations, then I think the mindset of both parties, the investors and the state, should be at a very different starting point. It's just like laying out the information where the grievances, and then instead of going, oh, this will be your weak point and this will be your weak point, to try to address, like equally be willing to first of all address and formulate where the problem is and see if it can be already addressed at a very early stage before it's a materialized dispute. But the current mechanisms, which is usually the notification, the cooling off period in BITs, and then the registration of the dispute and proceedings, arbitral proceedings, they do not encourage, it seems, like the current practice, how it has developed, does not encourage this initial, very amicable talks before the dispute is fully materialized and parties already take their position. And I would say yes, because everyone already starts to think about the potential litigation strategy and not to minimize the points that could later be used. So I think it's a mindset issue, first of all. I think those issues that state officials usually face in entering any amicable settlement procedures are pretty widely circulated. That the responsibility, who will take responsibility, is their authorization for state officials to settle if there is no binding court decision or arbitral decision. I think I would not go into them and repeating them, but I think the mindset of the system as it currently stands is not very welcoming, like honest entering in very honest settlement talks, not only as a necessary precondition to have later jurisdiction or admissibility already in the case. Thank you.
Thank you, Ilse. Evgenia, would you like to react to Ilse's remarks?
I actually had a question for Ilse, circling back to the very first question we discussed today, whether you think, and to other participants as well, whether you think it makes a difference how the internal arbitration team at the respondent state is structured, and whether or not, for example, a tender has been conducted to instruct an external law firm, what difference that makes for the prospects of a settlement of a case before an arbitration is commenced. Whether or not, for example, if an external law firm won a tender and is keen to get going and start, billing for its services, whether subconsciously they would potentially sabotage a settlement, or whether that is not really a concern, and how would this play out if, for example, there's just a full-time arbitration team in-house that is a bit overburdened and they really want the case to go away. What is your experience with that?
I would say at least I have no experience with these kind of potential problem issues, but I would say states who have followed the hybrid model, so that there is in-house team and outside counsel, I think that would already address this problem before it arises, because the state has its own mind, its own decision makers, its own policies, an assessment of the dispute, and outside counsels are there for specific tasks, not to conduct or brief on everything in the case. But I believe it might have happened, but I'm not aware of any such situations. At least I cannot imagine this happening for EU member states or something. Yeah, I think that's why states need to have this permanent team to avoid even theoretical issues of this happening.
Thank you both. Jim, any wish to react?
Yeah, no, Ilse put the question right, who will take responsibility? 2 days ago, Chad Wolf, the acting director of Homeland Security in the United States, quit because he didn't want to be responsible for security at the inauguration next week. Now, that's a pretty extreme situation, but I think it is an example of a state official who does not want to be held accountable for what many people see as a looming disaster. And in the context of settling a case, you're going to encounter, it's almost a truism, a reticence of any one individual to want to take ownership and responsibility for settling a case because they have no upside. It is best case scenario, nothing happens, like with Chad Wolf and next week at the inauguration, and no one will ever thank him for everything he did to prevent a worse scenario because no one ever sees what didn't happen. All there is downside risk. So there's a natural disinclination for state officials to want to take ownership of that. And how do you break that cycle? In some cases, we have been successful where maybe there was a domestic investment vehicle. We have managed to sell that domestic investment vehicle to maybe not the government or a state entity, but a sale brokered by the government. And that can, ways that don't require public officials to have to put their necks in the guillotine can be successful, but it's a very difficult and thorny problem. And perhaps with those hybrid model and good communication with the decision makers and use of outside counsel to perhaps provide an objective assessment of here are the real risks of going forward, and this claim has this value. That's potentially a role that outside counsel can provide constructively, is to give the officials in those departments who handle these cases the political cover they need to be able to say, I made the responsible decision and I prevented this worse outcome. And that's just sort of my observation I wanted to add on.
Thank you very much, Jim. That is a story that I hear recurrently. We have 1.5 minutes to go allotted to us, and I would ask kindly Lucian if he wishes to react on this issue. Please, Lucian.
Yes. Thank you so much, Professor Attila. I think there's a common ground there that nobody will take the liability to settle a case until some procedural steps have been exhausted. But even though those procedural steps have been exhausted and some parts have been moved forward, I have an example, a perfect example, I would say, where the Micula saga, where the government in Romania fought by more than 7 years now in 7 or 8 countries to resist enforcement for whatsoever reason. But then last year, in January 2020, the Romanian Prime Minister decided to honor and to pay more than $200 million to the Micula brothers in order to satisfy the award. And this has been a really big buzz in Romania, because the public opinion did not understand why the Prime Minister had to honor the award. And as a reaction, and again, I don't know this part whether it's linked or not, 3 days after, the Prime Minister had decided to step off and he had been replaced. Now, I think here we have the perfect example of what could happen if a decision can be taken to settle a case even 7 years after. And this is the point that I just wanted to raise.
Well, thank you very much, Lucian. Thank you all for sharing with the participants and myself your experience. You've been very generous in your preparation and performances, outstanding. So I thank you all very, very much, and I thank again the organizers for having given me this opportunity, and again to the panelists for bearing with my moderation and timekeeping. I will give back the floor to you, Nikos and Lucas.
Thank you very much, Attila, and thank you very much to the first panel. I think your discussion has been very rich, and we have a lot of different dimensions, and the absence of questions perhaps can only be attributed to the fact that everyone felt that there has been such a good flow that this should not be interrupted. So thank you very much for the excellent coordination and the panel. In the next few minutes, we are going to have the opportunity to hear from Jusmundi. Jusmundi is a fairly new search engine in international law, which in a very short period of time has won a number of accolades and prizes and has occupied a very good sort of position in the market. So we're going to have a demonstration of the search engine by its CEO, Jean-Remy, starting very, very shortly, and I can only give him the floor. Jean-Remy, the floor is yours.
Hi, I see a message that Mundi has a connection issue and will connect in 2 minutes. So we have to be patient. But there we are. The floor is yours.
Yes.
Hi everyone. Thanks for yep, okay, we'll share screen. Can you see my screen?
Yes.
Okay, great. So it's a huge pleasure to have this opportunity to introduce Mundi after such an amazing panel and a few friends inside this panel, and also before Gary Born. So thanks, Nikos, for this opportunity, and we are super happy to support EFILA once again. It's a pity that we can't meet in person this year, but I'm sure that that we'll have the opportunity to do it soon. So I will not lose more time, and sorry once again for the issue to connect. I have a few minutes, I think 10 minutes today, to introduce you to Mundi. As some of you already know, maybe Mundi is a search engine for international law that helps to do legal research and arbitrator due diligence in investment arbitration, public international law, and commercial arbitration. I will go through some of our features quite quickly, and of course, if some of you have some questions, you are quite happy to contact us. I would like to jump on something that has been said in the presentation just before, which is that there is no fragmentation of international law, but only a fragmentation of knowledge of international law. And I've never heard this sentence, but this is actually exactly why we wanted to build Mundi. The goal that we are pursuing is to collect all international law in all categories of laws in all domains, including the application by municipal courts everywhere, and to make that easily available to every lawyer worldwide, so it becomes much more available to everyone. So what you see on the screen is the search screen, and you have like a search engine that allows you to explore directly international law. So treaties, international cases, and wiki notes, and I will explain a bit more after. I click on international cases to show you the content that we are covering in terms of jurisprudence. And when you open on the right the type of case filter, you can have an idea of what we cover. So first, you have interstate cases. So at this stage, it includes ICJ cases, PCIJ, all interstate arbitrations that existed, and also the WTO cases. Okay, and in the tribunal court, you can have more details about it. Then you have investor state, which is our main topic today. And for those who already know Mundi, you had the experience that Mundi is now the most comprehensive database of investor state awards and related documents. But it is also now the case for commercial arbitration. We actually use the same techniques to find commercial arbitration award and additional investor state document, which is mainly to explore the municipal cases and to to find all the enforcement proceedings, set aside proceedings, and to collect award through that. Sports arbitration, that's something we'll launch soon, and the two other data sets we cover comprehensively are the Iran-US Claims Tribunal that we also discuss today with Jim, and the Mixed Claims Commission. Maybe just an additional word on commercial arbitration, because I know it's quite surprising the type of content that you can find on Mundi. These are, actual awards. So I will remove the national cases. You can do that by using the filter on the right, and just remove the type of document you don't want. To show you some award, okay, and the national annulment decision. So if I take, for instance, this doc arbitration award, you will see that the text of the award is fully available on Mundi, in this format that we process for all documents. And you have some PDF, and you have all the information about the cases, including the arbitrators, and sometimes the lawyers when this information is available. Okay, so it gives you a short idea of the content that we cover on Newsmundi, and also because we are discussing international law globally today, I want to tell you that the next steps is to integrate the other part of international law, for instance, human rights or other part of international arbitration. Now, when it comes to Newsmundi's features, first, this is a search engine, and which is super cool when you have all these data sets in one place, is that you can search among the different data sets with only one research, so by relevance. For a query like essential security interest, you will find treaties, international cases, and you see that among the cases, you have a lot of different jurisdictions. And when you are currently having an investment arbitration cases, you can totally refer to ICJ, to WTO, and so it really expands your possibility to find relevant or like the most relevant jurisprudence for your case. But of course, after you want to narrow down and to find the most relevant jurisprudence and not hundreds of jurisprudence military. So you will, for instance, add a near and military to find only cases that are discussing essential security interest in relation to military issues. Okay. Then you can narrow down even more to select an applicable treaty or a status of a case. Okay. When you are looking for something which is relevant for commercial arbitration cases as well, you will be able to access also the seat of arbitration of our commercial arbitration cases. I will jump now to another feature of Newsmundi, which is called the wiki note that you maybe know, which is a way to access the most relevant jurisprudence for every topical issue. And because we discussed today, police powers of the state, for instance, I want to show you. So you click here, you go through the tree, you access the police power doctrine note. You have here a table of content to help you to identify what is important to you, and then you just click to access the paragraph in which the author summarizes the position of the case law. And then you will, if you want to access, for instance, the case law which stand for this position, not excessive, that proportionality means that, just click on the footnote and you access the case law and the relevant paragraph directly. Okay. And if you click, you have access to the case on Newsmundi. Okay, so this is a short sneak peek on how to do legal research on Newsmundi. There are other parts of the platform, especially the possibility to access, on the of treaties, the possibility to access a jurisprudence that apply a specific paragraph of a treaty, or also to find jurisprudence that refers to each other. I will maybe take an example for a treaty. We discussed, the application of the Article 31(3)(c) of the Vienna Convention. If you want to find a jurisprudence that apply this article, you just select it. So here I am on the Vienna Convention. I select the paragraph 31(3)(c), and I click to access the jurisprudence. Okay. You can do that also with the award to find subsequent awards that are applying the one that you are reading. So this is for the legal research, and I will not say more on that. I want now to discuss the other part on Newsmundi that helps you to do your due diligence, your conflict check, etc. And because there are today so many information available about arbitrators, but that are totally scattered around the world, around the web, sorry, you can with Newsmundi access this information in one place. And I will allow myself to use Gary Born as an example. I hope he will. He will not. He will be okay with that. To show you his profile on Newsmundi. So these are not information, that we are gathering and saying like, oh, we believe that Gary Born is doing this or that. That's just a page, a profile, which is automatically generated from the database that we are collecting. So you really have to see Newsmundi as a data company. We really invest in collecting, processing this information, and after we create the tool to access them easily on the platform. So you have a little summary of what we have. You have the latest document rendered by such tribunals. analytics that help you to have some visualization of this activity, and finally the list of these cases. So as you can see, there are some investor state cases, commercial arbitration cases, and you can access the case on Newsmundi. Okay. So this is, for instance, an award that has been where Gary Bourne was one of the arbitrators, and so we have the complete text of the award. So probably we found this award through an enforcement proceeding or set-aside proceeding. Okay. So this profile is not meant, we at Newsmundi, we do not pretend that will help you to choose which arbitrator is the right one. We just want to help you to easily access all the information that normally you would spend day to collect together and to analyze. You can also access the information about the same activity, but as a counsel. And I see that I'm running out of time. I will maybe jump to these conflict checkers that here help you to identify relationships between arbitration actors, where you can put two individuals, two law firms, two states, etc., etc. And I will continue with two of our panelists today, Gary Bourne and Jim. And I found this example pretty interesting because, as you will see, Gary Bourne and Jim have never been together on the same case, as far as we know, because of course we don't have all the information, especially when it comes to commercial arbitration. But the conflict checker does not give you only the information about did these persons participated in the same cases. It will go beyond, also including people working at the same firm than these persons. And for instance, we have a case where James Carter and John Thompson are co-arbitrators, and both of them are working in firms at WilmerHale and at Hugh Joubert Reed. So this conflict checker really helps you to have a comprehensive view and to very quickly, actually the point of this feature is to save hours of your time. It's to access very easily all this information about people. You can cover, I will take an example now with my former boss, Alain Pellet, and you can take also, put the name of a firm directly. So if I take Alain and Curtis, you will find here direct relationship. So it means here you have two buttons. Direct means that they were on the same case, and indirect that they were not on the same case, but there are a relevant relationship that you may want to assess. And here you find relationship where Alain and Curtis were co-counsel for a state, but you will find also an old relationship where he was appointed by Curtis in some states here, for instance, in some cases. Okay, maybe if I can take 1 minute to explain a last point. So one exclusivity also Newsmundi is to allow you to dig into the case law for a specific arbitrator, for a specific law firm, or for a specific expert. And now I want you to focus on the filters that are here. And here you can select any firm. We are today here thanks also to Herbert Smith. You can easily go through the cases in which Herbert Smith represented one of the parties. And if you sort by most recent, you will see all the latest documents that we have in which Herbert Smith was counsel for one of the parties. Okay. After, you can add any research in the search engine. I will maybe show you how it works for an arbitrator. So if I take Gabriel Kaufman-Kohler, and I want to see if there are cases where the issue of umbrella clause was discussed, and Gabriel Kaufman-Kohler was one of the arbitrators, you just add umbrella clause in the search engine and you find 19 results in which this issue was discussed. Okay, so you can do it with a counsel, you can do it with an arbitrator, and last but not least, you can do it with an expert. So here, if you open the expert filter, it will cover individuals. So it can be a legal expert or a quantum expert, but you can also put a firm here. If you want to see only, for instance, FTI cases, you can do it. And yeah, you have also a filter to have a state or to choose a nationality of a party. So that's a very short and brief presentation of what Jusmundi can offer. You may know that Jusmundi is already used by many law firms already and several governments that are using for public international law, investment arbitration, or commercial arbitration. If you would like to have a short demonstration for you or your team, feel free to contact us. We'll be very happy to present the tool to you and to get your feedback, because that's actually what we use to continue to evolve. So I will not take more time. Thanks very much again to Nikos and to EFILA for this opportunity, and I look forward to listen to the other speakers after me.
Thank you very much, Saint-Remy. That is indeed very useful to explore Jusmundi a bit closer, although myself I have a subscription, as you know. Now we will turn to the final act of the day, not the final act of the conference, but the final act of the day. The conference has a continuation tomorrow, and that is a keynote address by Gary Bourne, which will be followed by a panel discussion, which is going to be moderated by Nondas Triantafylou from Queen Emmanuel. So without further ado, I would like to invite then Nondas to introduce Gary, and then following the panel. And myself, as indeed all of the other attendees, very much looking forward to hear Gary Bourne's views on the multilateral investment court. Nondas, over to you. Or perhaps I can make an introduction to a man who does not need an introduction. Gary Bourne is a very well-known, established authority, academic and practitioner in international arbitration. He leads the arbitration team of WilmerHale out of London, but he is widely known not just for his arbitral practice as counsel, as expert, as an arbitrator, from what we've seen in the Jusmundi in many cases, but also as a very well-established author. Continuing with the commercial break, his latest edition of his now 3-volume book has just been out at the end of 2020, and I'm sure a lot of you might have already ordered it or even start reading it. So what we're going to hear from Gary Bourne in the next 45 minutes is not relating to his 3-volume book, but is a distillation of his wisdom on where we are moving on towards in terms of ISDS reform and the various proposals for a multilateral investment court system. So Gary, over to you then.
Thank you so much, Professor Mistelis, and also thanks to Jusmundi for not just one introduction, which Professor Mistelis did so well, but in fact, I guess 2 introductions. Thanks also to EFILA for the opportunity, the honor to be able to deliver this lecture on the occasion of its 6th annual conference. It's an impressive track record, and I only hope that I can keep pace with those who in the past have delivered this this keynote address. Most importantly, of course, thanks to all of you, whether you're locked down or not, in whatever part of the world you may be in. I realize you're taking important time, valuable time to listen to us today. I say listen to us today because I have the great assistance of Louise Fuller from Herbert Smith, who will hopefully, we've never practiced this, but hopefully we'll be advancing the slide deck. My topic, as Professor Mistelis intimated, is the multilateral investment court, but I realized in thinking about that one can't really discuss the court without also discussing what came before. And the purpose of this talk is to put the court, the multilateral investment court, in a historical context, and then to ask hard questions, not to give answers, not to adopt particular positions, although I will express some, but instead to provoke debate. It's because I think this topic is so important that it deserves debate both in a historical context and otherwise. In terms of a roadmap of where we'll go over the next 45 minutes or so, you can see it on the current slide, and now I can too. We'll start with a recap of investment arbitration, what it has accomplished over the past 4 decades or so, a look at the critiques, the criticisms of investment arbitration, ISDS, a look at the multilateral investment court, and then a discussion about whether the court is the solution or whether, as I'm not sure we can exactly see it on the slide deck here, whether it is history repeated in not a good, but instead an unhelpful way. With that, let's turn to the recap. As we all know, ISDS, investor-state dispute settlement, sometimes encounters a lack of comprehension among the general public, and I think it's incumbent on all of us, and EFILA has done an excellent job in this respect in trying to make this system more transparent, trying to make ordinary people, but also politicians, even ones as distinguished as the European Commissioner for Trade, aware of what the system really is and what it isn't, because that awareness, I think, both enables us to have the debate that we ought to have with more information, and also helps to dispel some of the predispositions, some of the biases that may sometimes exist against investor-state arbitration. It is not a dog society. Instead, it is a fundamentally important aspect of today's international legal order. Moving on to the next slide. The investor-state dispute resolution system of today is characterized by extraordinary diversity, as we know. 3,200 or so bilateral investment treaties of every shape and form between almost every conceivable set of national pairings on a regional basis, pairings that cut across north-south divides, pairings that cut across language, nationality, legal culture and background, and the like. It's an extraordinarily flexible system, notwithstanding the existence of a global charter, in a sense, the ICSID Convention, that provides a framework for much of the investor-state arbitration that occurs. But the system is characterized by flexibility. Individual states, sometimes not immediately aware of what they're doing, but ultimately coming to that awareness, have tailored and adjusted both the substantive protections and the procedures that are provided for foreign investors and for the resolution of investment disputes. They've done so ultimately based on those states' needs and expectations. And if we could move hopefully back to the slide deck, we can see that the bilateral investor state system is also characterized, moving back a slide hopefully, also characterized by a high degree of enforceability and effectiveness. The current ISDS system allows states and investors to select tribunals for individual disputes after the dispute has arisen. Both the state and the investor on a level playing field are permitted to select the members of the arbitral tribunal, and very frequently they do. They're able to choose arbitrators based on the linguistic, based on the subject matter, based on the location of the parties in an individual case for that particular dispute. And that enables those tribunals both to be even-handed on the one hand and also expert on the other hand. Ultimately, this system is an enforceable system in large part because of the ICSID Convention. States can be held accountable for violations of international law. Investors can be held accountable if they bring claims that are frivolous or ultimately without merit. It's a system that has, over the last 4 decades, proved its value. It has contributed significantly to unprecedented levels of foreign direct investment and ultimately played a part, not obviously the only part, perhaps not even the principal part, in dramatic economic growth and the alleviation of poverty in all parts of the world. The investor state system is also fundamentally important in protecting basic human rights, the right to property, notions of pacta sunt servanda, protections against arbitrary state conduct, whether it's expropriation or denials of the minimum standard of treatment or fair and equitable treatment. Those are basic human rights that the existing system is designed to protect, and if we look in the next slide, in fact, has protected over the last 4 decades. You can see here, over time, the number of ISDS cases that have been resolved in the last 30 years, just slightly over 1,000 at this point, which create a nuanced body of international law, international investment law, which has done much to elaborate on the somewhat general terms of many bilateral investment treaties. If we can move to the next slide as well. And here's a useful snapshot, since we're doing a recap of investment arbitration, of how those 1,000 or so cases have been decided. Some 40%, 37% have been decided in favor of the state. 21% have been settled, and 30% or so have been decided partially or entirely in favor of the investor. The damages in those cases decided in favor of the investor have, needless to say, very frequently been materially less than those initially sought by the investor. Overall, a reasonably balanced distribution of wins and losses, states having perhaps a slight edge in the numerical count, but overall a significant number of cases, going back to the session we had just before the Jus Mundi presentation, a significant number of cases, notwithstanding perhaps the lack of focus on settlement, a significant number of cases amicably resolved. This system, moving to the next slide, replaced, of course, previous mechanisms which had failed. This system had replaced an era of gunboat diplomacy, or more recently, politicization of investor-state disputes, where the most politically active, typically the largest foreign investors, might receive some attention from their own home state, and home states that were large and powerful typically did better in these discussions than those that were less large and less powerful. Notwithstanding that recap, there has been criticism, substantial criticism of the investor-state system, as we know, over the past decade, decade and a half. That criticism, and you can see some examples on this and the next slide, has focused on a variety of aspects of the procedures of investment arbitration that I want to spend some time looking at in more detail. They focused on a lack of transparency. Investor-state proceedings are conducted in secret. They focused on a lack of independence and impartiality among investor-state tribunals. They're often highly paid corporate lawyers. You can see that in the Economist editorial on the current slide. A lack of consistency is pointed to in some criticisms between decisions by different tribunals, an inability of third parties representing the public interest in some cases to participate in proceedings, a lack of an appellate mechanism to ensure both correctness and also consistency of decisions. And in part to address these various procedural criticisms, a multilateral investment court has been proposed both by the European Union for all interested states in the world to adhere to, but also by others with similar concepts. The basic idea behind a multilateral investment court, it takes different forms, different proposals have been made, and I'll try to focus on what appears to be a common core of these proposals, is a first and a second instance tribunal, a first instance tribunal and an appellate tribunal with a standing body of decision makers, adjudicators, judges, selected by the states that are ultimately party to the multilateral investment court. The first instance tribunal, a little bit like a WTO panel to determine facts and apply law, an appellate tribunal to reverse legal findings or serious errors in factual determinations. Next slide, please. The Multilateral Investment Court is seen as providing a solution to the structural defects that I referred to previously, the procedural criticisms in the existing investment arbitration mechanism, to reduce the time and costs of dispute resolution, to provide transparency, to encourage consistency and predictability through binding precedents. The adjudicators that would be chosen by the states to people the Multilateral Investment Court would be full-time employees serving long terms with, in some proposals, non-renewable positions. There would be a prohibition against outside activities, and salaries would be like those of civil servants in the MIC's member states. There'd be a requirement for public international law expertise, but also fact-finding and adjudication experience. And there would be, similar to the WTO, a permanent secretariat trained to assist the adjudicators in resolution of individual cases. And what I want to look at now, moving on to the next slide, what I want to discuss, open for discussion, is whether the criticisms of the existing system of investor-state arbitration, which has proved successful in defending basic human rights over the past 4 decades, are correct, whether those criticisms, primarily focused on procedure, have force, and whether they justify the innovations proposed by the Multilateral Investment Court, and at the same time to think rigorously about whether the Multilateral Investment Court in fact is a solution, or whether in fact it is something else. And I'll try to go through in fairly short order each of the various procedural criticisms that I outlined before, and which one can easily find in other sources. Transparency was the first, and in some senses the most passionately embraced by critics of the existing system. You saw that in the Economist editorial and the New York Times editorial that we looked at previously. In fact, this particular criticism, we can leave the door open for discussing other criticisms, but this particular criticism, I think, has been very substantially answered. Arbitral tribunals, even before there were legislative changes, consistently, after a few early decisions that denied transparency, have consistently opened up many investment arbitrations to the public view. You can see examples of procedural orders by 2 tribunals on the current slide, and these are joined by a long list of other awards, procedural orders that one could cite to. Looking to the public interest in transparency of investment proceedings, tribunals have very frequently required that those proceedings be open to the public in important ways. The UNCITRAL has adopted rules on transparency, as many in the audience will know. I won't go through the details of those rules, but you can see examples on the current slide, both the written submissions, the evidence in many investment arbitrations, and hearings for presentation of the evidence would be, an argument would be open to public view if these rules, the UNCITRAL transparency rules, were adopted in particular cases. Moving on to the next slide, please. Interestingly, before we come to what I think is the final point on this particular issue, many states oppose transparency. There are certainly states that think transparency is a good idea, and in some cases that's a very understandable position. But a number of cases, you can see a few examples on the current slide, have in past circumstances, for various reasons, state interests, chosen not to have proceedings transparent, either because they think that's a better way to resolve the dispute, or because they have other interests at stake which they don't wish the public at large to see. Moving on to the final slide for this particular issue. There is, I would suggest here, a very simple solution that goes beyond what has already been done and which is easily adopted. Insofar as states or others think that transparent proceedings in investment arbitrations is a good idea, then one simply has to amend bilateral investment treaties or enter into new bilateral investment treaties. Some states obviously have done that. The Dutch model BIT, the US model BIT, CETA, all of these incorporate the UNCITRAL transparency rules, or could adopt a tailor-made set of transparency rules if that was what particular states desired. The Mauritius Convention provides for even more extensive transparency possibilities. Interestingly, there have been very few ratifications of that, and no EU member states have done so, suggesting that perhaps the desire for transparency, at least at the level of states, is less deep than one might think. But should it be deep, and should transparency be desired, that is not a critique of either the current or a possible future investment arbitration system. All one has to do is to take simple steps to design the system along the lines of what the Dutch model bid does to make it transparent or more transparent. If we could move on to the next slide, please. Third-party participation, which raises issues that are akin to those that are raised by transparency, the ability of non-parties, non-disputing parties to make their views known to arbitral tribunals before those tribunals issue their decisions, which can have an impact on the public interest. Investment tribunals in a large number of cases, Philip Morris, Infito Gold, Bear Creek, and dozens of other cases have permitted third parties, amicus curiae, to submit briefs and other submissions in their proceedings. If we could move on to the next slide, please. And arbitral tribunals have frequently given attention to those views. The Philip Morris case is, again, an excellent example. The European Commission has intervened very, very frequently, and non-disputing party submissions are, I think it's fair to say, a good deal more common in investment arbitration than before any international court. Some international courts permit, others do not permit amicus curiae submissions, but investment arbitration, both through the actions of individual tribunals and through amendments to applicable institutional rules and amendments to bilateral investment treaties, have made third-party participation a very real possibility, which is frequently exercised. If we can move on to the next slide, please. And again, as with transparency, there is an extremely simple solution here. Should more third-party participation be desired, again, using the Dutch model bilateral investment treaty, is a simple solution. Simply amend your bilateral investment treaty to provide explicitly for the type and level of third-party participation that one desires. Moving along. Another criticism that is frequently heard of the existing investor-state system is that of independence and impartiality. Arbitrators in investment arbitrations are said to be highly paid corporate lawyers, if only that were true, and to lack independence and impartiality. In fact, existing investor-state arbitration mechanisms contain what I would suggest are robust and highly effective mechanisms for ensuring precisely that, for ensuring that there are independent and impartial decision makers in individual disputes. That is achieved by allowing the parties, the investor and the host state who are in a dispute, to, consistent with time-honored arbitration practice, select the members of the tribunal. That is the ultimate level playing field, and it ensures that the two parties disputing with one another each are able to participate equally with the other in choosing those who will ultimately resolve their dispute. In addition to that basic and time-honored mechanism for ensuring independence and impartiality, all applicable conventions, bilateral investment treaties, arbitration legislation impose substantive requirements of independence and impartiality in precisely those terms on the members of the tribunal, with disclosure obligations on those members of the tribunals, both before they're appointed and after, to bring the party, make the parties aware of possible conflicts of interest. And finally, robust challenge and removal procedures in the event that those basic guarantees are not honored. Let's very quickly go through the next few slides where, because I know this is familiar to many in the audience, we can see examples of the protections for independence and impartiality that currently exist. The UNCITRAL rules contain both the substantive guarantees of independence and impartiality, as well as disclosure obligations and challenge mechanisms. Moving on to the next slide, please. The IBA guidelines, which, although not binding, are widely used in practice and perhaps more influential than some things which are binding, also impose the same obligations, not just of independence and impartiality, but also of disclosure, very far-reaching disclosure obligations that go beyond what exist in many national court systems. Moving along. And again, requirements for disclosure and duties of the parties and the arbitrator with respect to disclosure of potential conflicts. Moving on. The ICSID Convention containing similar guarantees. And of course, and let's move to the last slide for the finale on this particular set of issues. There is, of course, a further simple solution along the lines of what I've previously mentioned on other issues insofar as particular types of independence and impartiality, particular prohibitions or requirements for arbitrators are desired. The simple solution is to amend bilateral investment treaties and to provide explicitly for those prohibitions or those requirements. And I think it's worth stopping for a moment with that background and thinking about the extent to which a multilateral investment court advances independence and impartiality in this particular context, investor-state arbitration, or on the contrary, undermines independence and impartiality. Is it fair treatment, equal treatment? Does it guarantee impartiality as between investors on the one hand and host states on the other? For host states alone, without participation of investors at all, unilaterally to decide who will be the members of a tribunal whose mandate is confined solely to a narrow and limited set of issues which involve those states and their interests against the counterparties, the investors. I would suggest not. I would suggest that that amounts to what in some circumstances is called court packing. I would suggest that the reactions to court packing in national legal systems, whether it's the United States, Ecuador, Hungary, or elsewhere, the negative reactions to the notion that one administration or one party is permitted disproportionately to choose the members of an adjudicatory body on a specific set of issues. That opposition historically is exactly right. And that one does not achieve independence and impartiality. One certainly doesn't improve upon the existing guarantees by the solution suggested by the basic constitution of a multilateral investment court. I think on the contrary, that makes the entire court redolent of the Star Chamber. Not the Star Chamber in the sense of coercing confessions, but instead the notion of a body set up specifically to decide a narrow set of issues involving the crown itself. That is the ultimate and most devastating criticism of the Star Chamber. And I think one must ask rigorously whether that criticism also applies to a multilateral investment court. Let's look at the next slide, please. And one can see further evidence. We can go quickly through the next couple slides of the obvious points that if one looks at existing international courts, whether it's the ICJ or other international courts, the adjudicators chosen by states don't forget who appointed them ultimately. And if all of the adjudicators are appointed by one side or one set of parties, they won't forget that either. And the strong evidence of favoritism that is recorded in these various empirical studies is likely to replicate itself. And that's particularly true where the appointing states also have control over issues such as compensation, privileges and immunities and the like. Let's continue, please. A narrow point, double hatting, which has occasioned vibrant debate in many circles. The notion is that double hatting is bad because arbitrators who also act as counsel may let their counsel roles affect their thinking as arbitrators. That has certainly not been the case in international commercial arbitration, and double hatting, as I think many in the audience know, brings obvious benefits in terms of both allowing adjudicators to be younger rather than older, hence being more diverse rather than less diverse, and as well allowing arbitrators from less developed states to be chosen more frequently. Double hatting provides a ready path to appointment for younger lawyers with the type of expertise that both the MIC, but also existing investor state users want to see. Again, though, there's a simple solution. If one doesn't agree with my views with respect to double hatting, and there's certainly room for debate, fair room for debate there, then there's a simple solution. And different states may obviously choose different solutions to this issue. Part of the genius of the existing system is that there would be room for nuance, room for diversity. Double hatting can be prohibited in bilateral investment treaties if that's desired, and indeed, again, to single out both CETA and the Dutch BIT, that has been done on some occasions, and the ICSID and Central Draft Code is considering the issue as well. My own personal view is that a more nuanced, a more flexible, a more case-by-case approach focused on specific treaties probably makes more sense, but there's certainly room for debate on that topic as well. If we can move to the next slide, please. Forum shopping is a criticism that one not infrequently hears, and it's one that's sometimes aggravated by the possibility under particularly early generation bilateral investment treaties for investors without any material connection to a particular putative home state to bring claims against the host state in another jurisdiction without any real limitations on the number of proceedings that it might bring, depending on how many bilateral investment treaties in its corporate chain that it can find. And that understandably in some cases has aroused criticism. It is a fair point with respect to the existing structure of the bilateral investment treaty system that treaty shopping or forum shopping can occur. But there are two basic responses to this, which I think make this very much a non-point, a non-criticism, if I can put it that way. First, a number of decisions mindful of the evolving nature of the bilateral investment treaty system have relied on notions of abusive right, abusive process, to prohibit states, not to prohibit investors and to permit states to dismiss claims brought by investors where there has been an abusive use of treaty shopping. You can see a couple examples on the current slide. If we could move to the next slide, though, there's an even easier answer, which is to, again, the simple solution of amending bilateral investment treaties to either tighten up the definitions of investors or to introduce specific provisions, denial of benefits, or other provisions that will prevent forum shopping, treaty shopping of the sort that's been discussed. This is not a basis for criticizing the fundamental structure of the investor state arbitration system as it currently exists. It's simply a question of dealing with the procedures, tightening up the mechanics of how that system functions, and cure for forum shopping. And so far as states chose in their bilateral relationships to eliminate forum shopping, would be readily available to them. Let's move to the next slide, please. And the criticism, and one hears this not just of investor state arbitration, one hears this criticism also of international commercial arbitration, and perhaps even more vigorously of both national court litigation and litigation in international courts, with a focus today on budgetary constraints. Everybody thinks almost any legal process is too costly and too slow. Nonetheless, that criticism has been made, and made significantly with respect to investment arbitration. Average commercial arbitrations, I don't have a footnote for this statistic, but I do have a fair number of years in experience to support it. An average international commercial arbitration would take between 12 and 18 months. An average ICJ proceeding would take 4 years, and average investment arbitration, a bit more like an ICJ than a commercial arbitration, takes 3.86 years, at least if you look at the reported decisions and Susan Frank's analysis, very good analysis of that issue. The ISDS arbitrations tend to be slow for a couple of reasons. The most important reason is that under the ICSID convention and the arbitration rules, it takes a long time to constitute a tribunal, an arbitral tribunal, and equally importantly, many proceedings are bifurcated in order to deal with objections, state objections to jurisdiction. Those are raised in nearly half, 41% of all cases, while states, for better or for worse, are completely successful on those jurisdictional objections in only about 20% of all of the cases in which they raise jurisdictional objections. That yields a 8% success rate. But the frequency of bifurcation, and again, Professor Frank's work illustrates this very well, adds significantly to both the time and the cost of investment arbitrations. You can see this on the next slide. For investors and for arbitral tribunals, the cost is 50% again, and the time taken is around 50% again, as a result of bifurcation based on jurisdictional objections. One solution to this is to create more incentives for arbitrators and perhaps stricter timelines with respect to appointment of arbitral tribunals. That is certainly possible. It's done in many commercial contexts, and there's certainly no reason that it couldn't be done in the context of investor-state arbitration. Equally, and if we can move to the next slide, please. A multilateral investment court would not, it's almost certain, reduce costs, reduce the time it takes to resolve disputes, but it would instead significantly increase those costs. States thinking about a multilateral investment court ought to have regard to the ITLOs, to the ICC, the International Criminal Court, not the International Chamber of Commerce, and various criminal tribunals, whether for Rwanda or the former Yugoslavia. These various tribunals collectively cost billions of euro, billions of dollars, some of them billions of dollars on their own. And that is in the context of very limited caseload. States would ultimately bear the costs of the entire multilateral investment court, costs which they currently share, and do not share the costs of permanent facilities, a large secretariat, and the like. If we could move to the next slide, please. The appellate mechanism, needless to say, would add quite significantly to the costs of the proceedings. The appellate mechanism would, by permitting more grounds for challenging awards, increase the already robust ICSID annulment rate, 51% or so, to an even higher rate because of the promise of greater likelihood of success through increased grounds for appellate reversal of the first instance tribunal's decision. Obviously, the increased incidence of appeal would lead to greater efforts at the first instance level to make one's judgment appeal proof, which in turn would make that judgment even longer. If we could move back, hopefully, into some of the slides, good. And go forward beyond the slide that you just had. Ultimately, with respect to time and cost, the multilateral investment court almost certainly would not make proceedings quicker, it would make them slower and hence more expensive. It is true, investment arbitration could adopt some of the procedures, ICSID through its early dismissal provisions, which could be augmented along the lines of some arbitral institutions, the Singapore International Arbitration Centers, for example, to allow for more expeditious dismissal of baseless claims. The existing arbitration mechanism could be improved, but there is no legitimate basis to criticize the existing system in a fundamental way based upon issues of cost and time. Moving back to the slides, hopefully, another common criticism that one hears of investor-state arbitration is that tribunals have ignored the state's right to regulate. And in a sense, this gets at what I think is at the heart of many criticisms, or at least the motivations for many criticisms. We've seen how, with respect to most procedural issues, concerns that have been raised about transparency, double hatting, right to participate by third parties, time and cost, and the like, all have been either answered or not substantial criticisms in the first place. At the heart, I would suggest, of criticisms, and if you go back to the Osgood Declaration, one I think sees this, at the heart of these criticisms, even if it's not put that way, aren't procedural criticisms, but instead substantive disagreement with the outcomes. And here one sees criticisms frequently that the right to regulate of states has been ignored. One saw that in the New York Times editorial, one's seen it in the things that people like Elizabeth Warren have said. But that criticism, if you go and look carefully at the awards, decisions based on fair and equitable treatment, based on indirect expropriation and the like, simply isn't borne out by the evidence. There are, of course, decisions that in some cases are written more broadly than some users would like, some states would like. But fundamentally, the vast bulk of investment arbitration jurisprudence recognizes in emphatic terms the right of states to regulate. And I won't go through each of the various slides that follow, but if you take the time to work through those, I think there can be no doubt that the right of states to regulate, and to regulate quite robustly, has been respected in the overwhelming majority of all investor-state arbitrations. And again, there is a simple solution here, and so far as one doesn't accept that conclusion about how tribunals have treated the right to regulate. And that simple solution, to go back to a point that I made previously with respect to procedural issues, is to amend one's bilateral investment treaties. Many bilateral investment treaties in the second, third, and perhaps fourth generation of BITs do so explicitly. The US bilateral investment treaty is a good example. It defines expropriation, it defines fair and equitable treatment in terms that are suitable to the United States, and other states in their bilateral investment treaties can do so precisely, and they can define explicitly what they want the right to regulate to be, what they want protections for fair and equitable treatment to be. If we could move to the next slide, please. And insofar as the criticism is that states are disappointed with the right to regulate as recognized by bilateral investment treaty tribunals, the solution, as I said previously, is to amend your existing bilateral investment treaties. Finally, and this will be my last point before a conclusion, there's criticism about a lack of uniformity and consistency in the decisions of investment arbitration tribunals. I think a first and important question is there really a lack of consistency? In fact, if you look across those 1,000 awards or so, although one obviously sees differences in emphasis and nuance, one must remember that those 1,000 awards are decisions reflecting 3,200 different bilateral investment treaties with different standards. There are also similar standards across some treaties, and one can occasionally point to decisions by arbitral tribunals, especially on standards like fair and equitable treatment in early generation BITs, where there may be differences in emphasis, in tone, and sometimes outcome between different arbitral tribunals. But the existence of real differences about the same treaty language are, I would suggest, relatively few and far between. If we could move to the next slide. And those differences often arise because some of the issues addressed by bilateral investment treaties, again, fair and equitable treatment and expropriation, are genuinely difficult issues. And just as national courts sometimes express particular standards in different ways at different times, think about the UK Supreme Court as it addresses issues of independence and impartiality. So issues of that complexity, that nuance, obviously will be addressed in different circumstances by different tribunals. And again, a multilateral investment court, would it really, if we could go back a slide or two, please, a multilateral investment court, I think one has to ask, would there really be no differences in nuance the way that there are with existing tribunals? More fundamentally, though, there is a reason, an important reason, that there are differences in some investment arbitration awards, and that is because states exercising their autonomy to agree upon different bilateral investment treaties with different standards of protection and different procedures choose to adopt different types of international law rules. That's not a weakness, but instead a strength of the existing system, which reflects the autonomy of states to choose how they wish to regulate foreign direct investment, what types of protections they want to give in order to encourage that investment. And insofar as states don't like what existing bilateral investment treaties do by way of protecting foreign investors, then they should, the obvious steps, the steps that are democratically accountable and fair and equitable, to go back to a basic international protection, are to present one's arguments about why one interpretation is preferable to another, transparently to an arbitral tribunal. If one doesn't like the results, to adopt interpretations the way that the NAFTA Commission did so, and ultimately to transparently, through a democratic process, to amend treaties to provide different substantive protections. If one's real complaint is about the substantive result, then one should change the substantive protections, not to continue to raise procedural objections of the sort which, as we've seen in the last 45 minutes, have largely been dispensed with. It is not an appropriate way to fix substantive disagreement to pack tribunals with judges who are thought to be sympathetic. That's neither fair nor politically accountable in democratic societies. And finally, I think it's worth taking a step back again and thinking about how important it is, how important this subject is. International law has created a system over the last 40 years. Virtually all states in the world have participated. A system aimed at protecting basic human rights. It gives effect to autonomy, autonomy both of states and of individuals, to choose tribunals that are truly independent and impartial, using a time-honored and successful means of selecting those tribunals. This is not the first time that criticisms of the sort that we've seen have been raised. In 1933, the Reichsminister for Finance issued the so-called Reichsdirectives. Germany had a rich history of arbitration to resolve disputes both between private parties, between different Länder, different provinces in Germany, and between the Reich and individuals, individual investors and traders. In 1933, the National Socialist government, if we could move to the next slide, the National Socialist administration forbid that. It forbid it on the basis that arbitration didn't provide the type of legal certainty that national courts, national socialist judges would provide. Because arbitration lacked the public nature of proceedings in courts. Because arbitration lacked stages of appeal, the way that one would have in national courts. Because arbitration couldn't be relied upon to reach appropriate, correct, objective results in particular cases, substantive conclusions. And finally, because from a state policy point of view, it has to be considered that an extension of arbitration ultimately presents a disturbance to the trust enjoyed by state courts and the state itself. Those who would destroy, those who would undermine the existing system of investment arbitration should think carefully. They should think carefully about how history may judge them. It's a system that has worked fairly to protect the rights of both states and investors for 40 years. If one is going to replace that with another system, one needs to make sure that this is not a case of history repeating itself, but instead of a genuine solution to real problems. I hope that is sufficient to provoke debate. I'm sure it will be. Thank you.
Thank you very much, Gary. There's been a lot of food for thought in this lecture. It was an appropriate keynote, and it was actually quite erudite in the way it has been devised and delivered. So I think people would like to reflect, and in assisting with the reflection on the keynote, we have a panel discussion which will be moderated by Nondas Triantafylou, who is a partner at Queen Emmanuel in London. I would like to pass the floor to Nondas.
I would like to invite the rest of my panel to join me, again, with thanks to Gary and Lucas. And I would like to invite Kim Bang, Sam, Danny, and Kirsten, apologies. So, you know, I don't think any of my co-panelists need much of an introduction. I will simply mention for the record, we have Kirsten Schweit from Munich Linklaters, Danny Kayat from Paris, and Sam Rowe, based here in London, Debevoise, and we have Kim Beng Ta. I hope I pronounced that correctly, Kim Beng, from Gambia, the Principal State Council there, and therefore also representing in a way the voice of states. I think the discussion can begin maybe with Kim Beng, because the way I saw Gary present the case that we don't necessarily need a new system or a multilateral investment court was premised on the notion that the current system is actually pretty sound. And Kim Beng, perhaps you can start with commenting on that, and then people can jump in as well. What's your view on? Yeah.
It's quite an honor responding to Gary's. I think listening to Gary, it was quite interesting because from a state perspective, it's a view we get a lot of the time, and it underscores the divide in terms of how we view the current ISDS system. And it shows that irrespective of how much progress we make, there will always be that divergence between how the state views the ISDS system and how, for example, private practitioners and arbitrators view the system. I mean, I can speak from the state perspective, and the consensus is that the current system has worked to an extent for 40 years, but it's not perfect. And the rise in the calls for its overhaul is evidence to the fact that it's not been effective for everybody. As a result, you can see things like the ongoing UNCITRAL Working Group 3, extensive work on the arbitration process, as well as the withdrawal of many other states from the whole ISDS framework. That's a testament to the fact that there is an urgent need to overhaul the system. Gary has outlined some of the issues, and I mean, of course, he's sought to sort of cushion the blow with regards to the criticisms. But then it's unavoidable that these are clear issues. I mean, double hatting is a very clear issue. Impartiality. I think that's one of the issues that I remarked from what Gary said in terms of impartiality being an issue, not being an issue because there might be a concern with states appointing judges, thereby it being one-sided. But then if you follow the conversation, especially from key players like the EU that is pushing for the multilateral investment court, you'll notice that when you contrast that with existing multilateral courts like the ICJ, you see that it's not a one judge per one state system. And as well, it's not like a unilateral system where the Gambian judge, for example, sits over a case by the Gambian investor. As a result, I do not think it's a proper justification. And I strongly believe there needs to be an overhaul of the current system for it to continue to be effective.
Thank you. No, that's I think that's a great way to start the conversation, and perhaps we can begin with the adjudicators themselves, the core of either of those systems, the way they're appointed, perhaps the way they're perceived to be operating and thinking. Sam, I see you nodding. So did you have a comment, first of all, on the current system, the concerns that Kim Beng is raising, and then perhaps also you have any comment on sort of the proposed system, sort of in juxtaposition?
Sure, thanks, Nantes, and very happy to be here with everybody this afternoon. Perhaps just a few comments. I mean, it does strike me, and I very much agree with Gary on this point, it strikes me as curious that the EU's answer to a system of appointment of arbitrators that is supposedly biased because it is an appointment by the parties is being replaced by a system where just one of the parties has a say in the appointment of the potential adjudicators. I mean, that seems to me to create much more of an appearance of bias than I think Gary referred to it as the ultimate level playing field of both parties having a say. And certainly from my perspective, when I look at the way that the current system works, you know, there's very much a market dynamic to it. When you're thinking about who you want to appoint as your arbitrator, whether you're on the investor side or the state side, I don't think you're sort of thinking, oh, who is this sort of well-renowned person for taking my side and for always taking the investor side or for always taking the state side. It's much more nuanced than that. You're thinking in terms of who will, you know, who is persuasive, who is credible, who will be able to take the other members of the tribunal with them in accordance with what they believe to be the answer to the dispute. And I think that that market dynamic has worked quite well for us in terms of building a system of dispute resolution. I'm not sure that the comparison with purely state courts, interstate courts, is quite as apt as it may be on first glance, because of course in those courts it's only states who are parties to the proceedings. So everybody, all of the potential parties to that court, are getting a say in who the ultimate deciders, the adjudicators of their disputes, are going to be. Whereas the issue for me with the MIC is that the investors are just completely excluded from that process. And I think, you know, what the concern that this really gives rise to is that the decisions coming out of this body are going to be more pro-state than you see at present. The adjudicators are appointed by the state, they are going to be paid by the state. And you know, when we look at standards for objectivity, for impartiality, it's always about object appearance of bias. It's not, nobody's suggesting there's going to be any actual bias, but it's about creating a mechanism that objectively looks completely without bias, without partiality. Some of the counter arguments that we've seen from the EU is, well, look, states have investors, capital exporting states have investors, so they're going to take both sides of the equation into account when they're deciding who to appoint as their adjudicators. I think with respect, that first of all only applies to the category of states that are capital exporting as well as capital importing. We know that that's not all states. And I think with respect as well, it's just not really how we see states behave. If you look, for example, at the Free Trade Committee under the NAFTA, when they were issuing their interpretations of the NAFTA, those much more often tended to be pro-state interpretations than pro-investor interpretations. For example, the fair and equitable treatment standard was redefined as the customary international law egregious conduct standard. So I think for all of those reasons, you know, that the idea that state appointment of adjudicators, it really is quite problematic and not necessarily going to solve the issues that have been identified.
Thank you. No, that's thank you for those comments, Sam. And you know, on the FTC in particular, I mean, that is more of an executive body, so it doesn't really surprise me that states, and especially since it's a tripartite one, if states decide to narrow protections, that's okay. I think the issue there was that it wasn't done in a formal mechanism of amendment. It was done by way of commentary, and that was an uncomfortable way of doing that. Kirsten, you know, I know that you also have views on, you know, appointment of judges on the multilateral court. Perhaps you also have some views about the current system of arbitrator appointment. But please, the floor is yours, just for your comments.
Yeah, thank you, Nontas, and thank you to EFILA also for having me. It's a pleasure. I pretty much concur with what Sam has said already. So it's a pity to change a working system, and the statistics that Gary has shown, I think they prove that there's not such a bias. That is now the starting point to change the system, or one starting point, and to build up a completely new one. And that's a downside, but at the same time, I think we always can draw some positives from every development or disruption. Even now in the pandemic, we see maybe some positive effects. So let's try to look at the positives of the proposed system. And it may well be, I can imagine, that we would have different personalities also. Careers of judges can be very different on an international level, and can be an interesting mix of people aiming to have such a career. So I think there are pros and cons we really need to weigh carefully. So just imagine a more state court or academic type of person, and people judging this kind of disputes can create a certain legitimacy, and I wouldn't say that necessarily state courts cannot also be challenging for the states paying and appointing them. Just looking at the German Constitutional Court or the European Court of Justice, it's not always probably the state's pleasure what they decide. So I find it difficult at the same time to rule out that improvements can come this way. But of course, we will have to discuss other open questions. So we don't know who actually will be the parties to this kind of system. How many countries will go with the new system? Will there be real platform diversity, and how exactly will it look like? So this is also uncertain. I think that's a main downside we could discuss later, that we have that that abolishment of an existing system before having a real alternative.
Thank you. Yeah, I think the diversity point, which Gary also made quite forcefully, in the sense that the current system, it's basically a rotating free market system where different people from different parts of the profession, academia, etc., emerge as arbitrators for a finite amount of time before they revert back to their natural environment, so to speak. And then, you know, this whole circle repeats itself with the markets, broadly understood, of course, as the practitioners observing the quality of individual arbitrators and then deciding whether to reappoint them. But I wanted to ask Danny, you know, now we are sort of moving towards the more deontological aspects of what would you suggest, or would you suggest any modifications or tweaks, assuming that we are still within the MIC proposal, that would allow the MIC to become a bit more attractive? I know this is tough in present company, but what would you say? What would you say would be some additional changes that could be made?
Thank you very much, Nontas, and indeed, thank you to all of you. This was extremely, I think, interesting and stimulating what Gary has mentioned. I think I would start from perhaps the premise that what is happening currently, if you look at the number of states advocating the same position, you know, may also be, this, to use a word that Gary has used, you know, maybe this is also an expression of, you know, the willingness of states and perhaps also the democracy in a way. You know, we maybe need to respect it. The BITs were here because states wanted them, and now there's a change. So perhaps we need to adapt to it and not necessarily look at it in such a necessarily negative way. Again, I come from the same background as Samantha, as Kirsten, as Gary, probably as well, but there needs to be some adaptation, no doubt about that. And picking up on the thought that Samantha had, which I share completely, I think there must be a way, and there should be a way, to reintroduce the civil society, or certainly the economic society or the business into this whole discussion. I think, Samantha, you mentioned that it's not necessarily the case that just necessarily always rule for a state, but sometimes they could rule in favor of the investor, to which, you know, they have their own national before them. And that's key, I think, in this whole system. If states are able to understand that in taking the very strong positions that they are taking currently, certainly they are advancing their own program and their own agenda, but they are certainly also undermining their own investors. And if there is a voice within the business community that can reach the state to be able to balance what is being discussed and what is being debated. I think this would be the best way. I know it's being done. I know this voice is not necessarily very audible, but I think that this is, to me, the ideal situation to get to a certain level of playing field. It seems that the new system is here to exist. It seems that we're going to have to adapt to it. But let's, as Kristen mentioned, to the extent possible, include the voice of investors in it and do probably more lobbying. Perhaps it's a longer term issue, but this is, to me, one of the key aspects to a change in the system to make it more balanced.
I wonder in that regard whether, you know, the criteria for selecting members of that court could be more oriented towards market experience, professional experience, you know, having firsthand understanding of how things work on the commercial side, as opposed to coming from a more traditional judicial, if you will, background, whether that's a school of judges or, you know, a state court appointment. Now on the issue again now of transparency, which is another big criticism of the existing system. I tend to agree with Gary that that criticism is a bit overblown, given the trend of the past, what is it now, like 15 years, where leading, of course, with treaty arbitration leading the way, you have greater openness in proceedings, you have third-party participation, different mechanisms, and whole treaties like the CAFTA actually premised on open hearings, right? So it's not a secret tribunals world anymore, as it was perhaps back in 2000, or at least that was the allegation that it was with the NAFTA. So would you, Kim Bang, coming back to you, I mean, would you expect material improvement in the context of a, in this case, multilateral investment court or a otherwise regional investment court? Would you envisage the situation becoming materially better with respect to transparency? And if so, what would be the areas that you feel still need a lot more augmentation in that sense?
Thank you very much. I think with regards to transparency, it's one of those very valid criticisms, because first and foremost, I haven't seen any cogent evidence that the issue of transparency necessarily affects the outcome of arbitration proceedings or has any direct effect on enforcement. So as a result, I do not personally believe it's such an issue that will necessarily be addressed by the MIC. But then again, I agree with you that there are other areas, and just to piggyback on if you permit me, on the question you asked Danny, with regards to how the MIC could be improved to sort of fill in those criticisms. One of the areas that I think we could look at is in the sense that the MIC doesn't have to fit the mold of the EU proposals, but then we could adopt certain innovative ways of constructing the framework. For example, one of the key areas that has been proposed is judges sitting for a single term, which guarantees that there is no need for trying to make ovations to states in rulings. Another proposal is, for example, having appointments being done, like, for example, countries appointing 2 judges, one judge appointed by the state and another judge appointed by the Chamber of Commerce, for example, which represents other interests. A further innovative method could be the Canada-EU framework, where, for example, you have a panel of judges that are permanent, and then for each case you have, for example, an expert that is appointed from the private sector. So those are the kind of innovative measures I feel we could explore, but I don't think transparency per se is a concern that warrants much looking at.
Mm-hmm. I mean, Sam, do you share that view that transparency really isn't a selling point practically for the MIC, given where things are now in treaty arbitration?
Yeah, I really do, Nontus. I mean, the very first investment treaty arbitration that I worked on as a junior associate was under the NAFTA everything was published on, it was against Canada, everything was published on Canada's government website. It was an open hearing. I don't think at that point, giving away my age, it wasn't live streamed on the internet, but it was open and people could come down to the World Bank and watch it. And I think the only people who actually took advantage of that were law students from Georgetown. And I think this is just one of those issues where Guardian journalists feel like they can sell a lot more copies of their newspaper if they rail against secret proceedings than they would if they actually attended those proceedings and reported on what was actually happening in them. All of which is to say that I think it is completely overblown. And also I think Kim Beng's suggestions with regard to appointing adjudicators are just brilliant, and I will propose him as chair of the MIC immediately, because those are really good ideas.
No, I share the view that a lot more can and should be done if this is to be the mechanism with respect to identifying who's going to be on that bench and how they will rotate. Because even if you have single-term judges, if you put them up there for life terms or 25, 30-year terms, you are freezing the court for very long periods of time, practically. Kirsten, any comments on we have two parallel discussions going, one residual, one on appointments, and one on transparency. So you can comment on either.
Yeah, I have to go with transparency actually, because only recently I watched on YouTube the oral hearing in the Vattenfall Germany case. So I can't imagine any more transparency. And I think there has been so much improvement already. It's probably more a question of complexity. So it's just so complex that the usual newspaper journalist that Sam referred to has difficulty in explaining that to the broader public and really understanding all the details. So I would say it's much more a result of all those different treaties and different rules that Gary also referred to. So it's not necessarily a divergence of decisions, but it's just so many different bases of law that have to be dealt with, and the differences are sometimes difficult to explain, or maybe just an arbitral tribunal doesn't feel to have the task of explaining why under this treaty it decides this way, while under another treaty it would decide otherwise. So it's also maybe not enough guideline for states also how to conclude and how to draft future treaties in order to achieve a certain result. So again, I'm always trying to look at the positives, and this could be something that the MIC system could improve, where you have a more systematic and structured approach, looking beyond the individual case and trying to establish a certain level of predictability across different treaties and cases. That's a hope, but it will take some time until we see if that hope is fulfilled.
I think your comment is actually a great segue to another area that I wanted to explore with all of you, which is the evolution of substantive law under a MIC as opposed to tribunals. But before that, I wanted to come back to Kim Beng and his comment about judges on the MIC. There was a question that came regarding your point, Kim Beng, and that's that. There is an argument that in the ICJ, for example, which is one of the parallels that people use, you have state-appointed judges judging states. So there is a symmetry in a way. And there was actually an interesting slide from Gary about some observations that Eric Posner made about the psychology of judging states, and how if you've been appointed by a certain kind of state, you tend to favor similar states in judging them, etc. But quite apart from that, the MIC is quite different, because it's going to be state-appointed judges judging investors as well, judging individuals, elevated to the international law plane. Do you see that as a concern in and of itself? I mean, is that a valid sort of difference, or?
No, I don't really, to be honest, I don't really see it as a concern. I think it's one of those concerns that is equivalent to the same concerns that have been expressed from our side with regards to arbitrator impartiality. The reason why I used the ICJ example was more about to talk about the mode of appointment, in the sense that it's not a one state per judge type of appointment, but more of a group of judges that are expected to be impartial and are governed by certain rules which govern impartiality and conduct. But I think even more convincing is the fact that ISDS basically is commercial litigation. And if we look internationally at commercial litigation, more commercial litigation takes place in national courts than it does in ISDS, albeit it's domestic litigation. But then domestic judges are appointed by states in most cases, but except for countries which have concerns as to judicial independence, we do not necessarily see litigation between states and commercial parties or private parties being mostly pro-state, basically because the judges were appointed by the state. And so for me, I think if we, and which is being proposed right now, Anti-Trial Working Group 3 is working on code of conduct. If we had judges appointed by states, or we use sort of innovative methods, and we had codes of conduct in place, then I do not believe the issue of impartiality really comes up, unless there's some evidence to suggest that judges that are appointed by states necessarily will rule in favor of states. No, and just to add as well, sorry, if you look at, I mean, from a state perspective, and when I talk to friends, a lot of the time when we are appointing arbitrators, you hear one thing, yeah, this is a state-friendly arbitrator, or this is an investor-friendly arbitrator. It does happen in virtually every case. So I think it's equivalent, if you ask me.
Yeah. No, and I think Kirsten was making this point earlier, that you have all sorts of national courts, very high-level courts, reviewing state conduct, and you don't necessarily automatically think that they are somehow biased in favor of the state. Although, you know, opinions can vary on that, I suppose. Danny, did you have any comment on this, because you're on my list for the next area that we're going to be covering, the substantive law area?
Just briefly to say that listening to Kim Beng, I think that the main question, as I see it, in terms of, you know, how those adjudicators will be deciding as compared to the legals, to the national systems, and to the judges, is one, perhaps at the end of the day, of political influence. It is really a question of whether there is going to be political influence or not, and at the end, and perhaps because this system also means that the court, or whatever court this is going to be, the multilateral investment court or another one, that's still going to be not a court of the state. It's still going to be a court that is outside of the national system of that state. And therefore, maybe, I mean, we've used this word many, many times in investment treaty arbitration, especially in the early days, depolitization. So really, maybe this is going to help to depoliticize, that's the right word probably, depoliticize the disputes, and therefore making those appointees less prone to political influence, hopefully. I find myself, you know, defending the MIC, which is not my natural inclination, but perhaps given Gary's presentation, we sometimes need to do so.
I think we owe it to ourselves and to the audience to be fair. You know, it's not about, it's about debating some of these ideas, and they all have their own merits. So, you know, so the MIC, Danny, staying with you at least briefly, and I'd like to get the others to comment too, an engine for developing investment law, looking forward. So would you expect the MIC to sort of go in a different direction, or would we even want the MIC to go in a different direction from the current jurisprudential, you know, engine, sort of that's issuing decisions broadly consistent, but not always, you know, that sort of thing? What would be your idea of the MIC's operation in that sense?
So that's the million-dollar question, and that's the most difficult one. States, of course, will tell you it has to change entirely, and investors will tell you, oh, we have to keep at least some of what has been decided up to now. The key is going to be at least the confidence that this new system, you know, however it's going to exist, I mean, it's not clear yet, perhaps. The key is going to be those very first decisions. and first of all, the appointees, the adjudicators, and then the very first decisions. Are we going to be able to trust, all of us actually, states, but certainly private parties and the lawyers generally, or those who work in the law, are we going to be able to trust the system or not? If the very first decisions are a deconstruction piece by piece of what we have up to now, then I think it's, that's it. There is no way this is going to be trusted by anyone. It's going to be a very big problem. If we end up having, discussions about certain standards, I don't know, fair and equitable treatment, the scope of it, or regulatory powers of the state, then, there's scope to discuss. But let's see if the system is going to indeed exist, as it seems that it will, perhaps. Then let's see those first decisions, and hopefully they will not be deconstructing the previous system, but adapting it.
Let me go to Kim Beng very quickly, because I have a suspicion that he might have a sort of an idea for more broader changes maybe at the outset. So Kim Beng, would you like to comment on the question as well?
Very clearly, I think that's one of the most attractive factors of the MIC, in the sense that one of the greatest criticisms of the current system is consistency in awards. And I think that consistency and predictability, especially from a state point of view, is the bedrock of the arbitration process. If you look at the development of international law and arbitration, it takes place on the different judicial systems and different forms of law. But with the current proposed system, there's a strong belief that we're going to move away from a system where each tribunal rules separately on the same issue, to a point where we create a sort of international jurisprudence in investment law. And the effect of that is it slowly takes us away from this uneven system of investment law towards this near uniform system of investment law, thereby being a magnet for potential litigants to this system of dispute resolution.
Thank you. I would only note, before I'll come to Kirsten now, just to see your comments, Kirsten, just with the footnote here that, I wouldn't expect the MIC to be a global court. I mean, maybe, in the distant future, but there is a very real possibility that we'll be talking about the MIC plus a bunch of ad hoc tribunals under existing investment treaties, plus some other regional courts potentially founded after the, and modeled after the MIC. So maybe, in that sense, the expectation can be moderated somewhat about, global uniformity. But Kirsten, would you have any comment also about the direction of the MIC, the opportunity to reform certain things, the opportunity to change the direction of the law through the foundation of a new court?
I mean, I agree that it will be difficult, at least in the near future, to have a global MIC court system. I don't see that. It will take too much time. And when looking at the New York Convention or the ICSID Convention, it's an enormous work to get there. And so I think, again, in terms of opportunities, it can be good to have some kind of competition between systems. So if you imagine just a few states taking part in that mixed system and others sticking with ICSID or ad hoc arbitration, classical ISDS, it may give us some insights into where investors go, or if there are other things that outweigh maybe downsides or structural differences. So in the end, I would say what investors want, at least the clients that I talk to about the topic, is that they want legal certainty, they want stability, they want to know where they get to. And it may well be that a not so ideal procedural framework, if it's combined with good substantive protection, can work perfectly well. And sometimes in my practice, I see clients that would even take a not so successful decision if it just happens in time. So if they can move on with their business. So that's all factors to look at. What the benefit is, and my main wish for the ongoing discussion is we now have the chance to really look at the core of the system. What are the shared interests and values? What on which values do we agree? What do we defend? And what is the common purpose? And that needs to be the guideline. And somehow I think, again, coming also to the topic of diversity, referring to the reference to the Third Reich guidelines that Gary made, I really had to think about that. Also being a German national, is that really what happens now? Is it really so bad? But maybe we are just in a different context. In 1933, we had a dramatic economic downturn, while today the stock exchanges the values rise day after day despite the pandemic. So it's maybe a different discussion, and maybe more a result of a converging world economy. So different countries and regions get closer to each other, and that creates tension. Each one wants to participate, and so I really see those benefits of the discussion. Sometimes it hurts to get to have progress.
No, that's absolutely fair enough. And you know, I also don't really share the idea that this is some kind of extreme statism exercise to establish a court like this. But it certainly does result in some concentration, you know, in creation of a bureaucracy, of a new bureaucracy to resolve certain types of claims. I think that's pretty clear. And Sam, from your perspective, I mean, you know, what direction could this institution take, or would it be best, as Danny was saying, simply to stay the course and try to homogenize a bit more, or build threads of jurisprudence in a way that increase investor certainty and legal certainty?
Yeah, and I think that, as Danny said, this really is the million-dollar question, because when I look at the critiques of the investor-state system, I think this perhaps for me is the one that has the most resonance. You know, when investor-state arbitration really sort of took off, it was still very much viewed in that kind of ad hoc model. Okay, this is a dispute under a treaty, and this tribunal has jurisdiction over these parties to decide this specific dispute. And I think it's really hard to argue with the notion that it has grown into something that is much more systemic, and that is, as a system of law, you know, it really should abide by fundamental notions of the rule of law. And Kirsten has identified a number of those: predictability, legal certainty. So I absolutely agree that that is something that as a community we need to have right front of mind, and be thinking about how to develop that further. And certainly there are institutional features of the MIC which will lend themselves within that body to developing a consistent body of law, you know, rightly, wrongly, pro-state, pro-investor, that will generate more predictability, and it will generate more certainty, not least the appeal mechanism and having one panel of judges to decide all of the disputes. But then I think the question is, well, assuming that the MIC is not going to be a global institution, and I think we've all agreed that that is very unlikely to be the case, what is its broader impact going to be? Are we, if it does end up taking this sort of perhaps more pro-state bent, are we going to see the MIC body of law develop, and are we going to see the ICSID and the ad hoc body of law develop in a different direction? And it's not completely unreasonable to suspect that that might be the case, and we have an example from recent history with the Salini test. The Salini test was tribunals saying that in the ICSID convention, investment has a definition that it doesn't necessarily have in bilateral investment treaties, and it's an outer limit, and it can be used to defy jurisdiction and to prevent an investor from bringing a claim that they legitimately would have under the bilateral investment treaty. So I think for me, and I'm afraid I don't have the answer to the question as to whether we're likely to see fragmentation or coherence, but I think it's certainly a risk that is out there, and it's something that we should be thinking about as we look at the various proposals. And perhaps just the other thing to mention here is, you know, the impact of the MIC will very much depend upon the uptake of the MIC. Which states are going to sign up to it, and not just which states, but which treaties are they going to bring within the rubric of the MIC? Are they going to opt in for all of their existing treaties, or is it just going to be their treaties going forward? We only see reference to it at the moment in the recent EU trade agreements. And of course, those trade agreements, if you look at their substantive provisions, are very different to the early generation bits that we saw before. You know, Gary referred to a number of different ways in which they are fundamentally different. You have fair and equitable treatment provisions that have an exhaustive list of actions that can constitute a breach of FET, which is a totally different approach to traditional bilateral investment treaties. So I'm afraid I've just raised lots of questions and not really given you any answers.
But that's all. That only reflects the nature of the topic, I think. I mean, the topic, you know, the more you explore it, the more likely you are to find questions than answers. And I think, you know, ultimately the impact of the MIC, I think, is a quite interesting question, because on the one hand, we're dealing with it as an abstract topic, like, you know, a court dealing with treaty cases. But you were talking about, you know, country treaties. You know, EU countries are terminating their treaties internally. They're keeping those with third states, but there would have to be an amendment to which third states are going to have to consent in order for the MIC to become relevant for those treaties. And that sort of buy-in, I think, is going to be difficult. Perhaps Kim Ben can give us a sense of concerns that might exist in that sense. So in a theoretical scenario, Kim Ben, where you know, there exists an EU MIC, do you see it as an easy process to get non-EU parties to buy into an amendment that's going to bring the cases to the MIC?
Yes, I do believe so, especially if such a MIC is reformed to suit the desires of new adoptees. And why I say this is because with the current AFCFTA in Africa, which comprises, I mean, almost 58 countries potentially, it's a move that is increasingly seen. And my prediction is that as we move away from having these regional blocks, we're going to start seeing a scenario in which we have inter-regional block trade agreements, for example, the EU and the AFCFTA. And once you have that, there's the possibility of having a new mix system under that particular agreement, which hopefully already will have more than 60 countries as adoptees. Now, the issue is, and speaking from an African perspective, is that our history with tribunals under trade agreements hasn't always been positive. Take, for example, in 2012, there's a trend when awards or judgments go against states, consecutively states tend to withdraw en masse from these court systems. Take the SADC tribunal, which was scrapped in 2012 because of a judgment against Zimbabwe. I take South Africa, for example, putting a freeze on bilateral investment treaties and scrapping FET and creating fair administrative treatment. And so I think that's what we're going to see. But the key is, if we have a mixed system and it works for the members, we're going to see increased adoption. So that's the key. If we make it work, if it's quick, and if it's cost efficient, which is one of the major issues for African states, if it's quick, it's cost efficient, and it's predictable, then it's inevitable that other member states are going to get drawn to it like bees to honey.
Let's talk about that. I think that's actually a good transition to the topic of time and cost. And you know, talking about time, Kristen, I mean, do you see or would you expect a MIC to really be materially faster? I mean, you know, we have some experience with standing tribunals. We have some experience maybe with the ECJ and these kinds of courts. Would you expect an acceleration as compared to these more ad hoc proceedings where sometimes arbitrators err on the side of giving parties more time instead of imposing strict drop-dead type deadlines that courts sometimes do?
My personal view, to be very honest, I try to be positive, but there I don't have much hope. I can't imagine that system to be much faster or cheaper. I was shocked by the numbers and the references made by Gary, but I think that's the bottom line. And I don't think such a court system will be any cheaper or faster. Quite the opposite, at least in terms of cost. I guess.
Yeah, and Danny, do you agree with that assessment, and would you have again any other suggestions in terms of?
I fully agree. One thing I was thinking when you were talking about time aspects is so if this new system ISDS system is going to appear, well, it has to be faster, of course, than the existing, but certainly faster than the local courts. And here, this is something that can be achieved, perhaps not not such a difficult way. There are many countries where proceedings can take years, maybe 7, 8, 9, 10 years. In Latin America, for instance, the proceedings are extremely long. So one positive and selling point for the MIC could be again, I'm looking for positives, could be that it would certainly be quicker than the local system, which is in and of itself already an achievement.
And Sam, do you broadly agree on the timing point?
I do, yes, absolutely, on the timing point, and perhaps just another couple of points on the costs. I mean, I think, again, looking at what the EU has said, they've pointed to the fact that you don't need to vet arbitrators and to increased consistency in case law as reasons why the proceedings will be cheaper. I take the point on the vetting. It's, as everybody on this call knows, it is a painful and expensive process. But obviously it's one that our clients at least think is worthwhile, because that they then have some control in the adjudicatory process. So that's a sort of cost and balance. On the consistency of the case law, I find that really hard to understand. We don't litigate in the black and white, we litigate in the grey, and there is always hay to be made in the grey areas. And I think it's what, if you look at ICSID costs, the cost of the proceedings themselves is really quite a small percentage. The cost of investor state arbitration is really legal fees and expenses. And I don't really see any reason why those would be much cheaper with a MIC than they are with an ad hoc proceeding. Perhaps just one other point to make, and I don't want to suggest that I'm against transparency in investor state arbitration, I'm absolutely not, but I think it is important to recognise that it does come with quite significant cost for the parties. If things are being published for the whole world to see, they need to be scrubbed and scrutinised and potentially redacted. And if we're inviting third parties to make interventions, then the parties to the dispute need to have an opportunity to respond to those. So I don't think the MIC is by any means this sort of solution to inflated cost and time in investor state proceedings.
I mean, I would agree with that generally. And oh, Kimbek, did you have an observation?
Yeah, sorry. If I may, I agree. I'm not very optimistic about the timing, because when anything is subject, speaking from a government perspective, when anything is subject to political considerations, there's always those little inefficiencies that creep in. So I'm not optimistic with regards to timing. But with regards to fees, I'm rather optimistic, because if we look at the EU format, which is more of a state-funded court system, I mean, that potentially becomes a very attractive system to investors, who obviously have to pay legal fees, which they do anyways, but then have to avoid paying for all these administrative costs, arbitration costs. And also, if the MIC increases on the efficiencies of the current system, then that probably translates to more efficiency and cost effectiveness. So cost, yes, but time, normal.
Yeah, I mean, I think Gary was saying that you're going to have to pay for the court to exist and for the bureaucracy and everybody, but that's a way maybe of subsidizing access to justice in a way, because it is true that compared to legal fees, maybe the administrative fees and the institutional fees and arbitrator fees are not as high, but they're non-negligible in cases, and in some instances we've seen cases where they reach high 6 and 7 figures. So if it's something that can be avoided, it's not small change. Well, I think this concludes our panel today, and I sincerely want to thank each and every one of you for your contributions, and also for donating your time so generously. I know we went a bit over. I guess I should be thanking our audience as well for their patience and attendance. And I'll invite Nikos to take over from here, again with my sincere thanks to everyone.
Thank you. Thank you to Gary. Thank you to this panel and to the previous one. I think we really had a stunning day. And I think it is at least of the same quality as of the previous EFILA conferences. So I'm very, very happy and proud that despite the pandemic, we were really able to cover a lot of ground. And I'm particularly happy and excited that we had a lot of state views coming in, because that proves that we are interested in hearing from states and having an actual dialogue, which doesn't mean necessarily that we agree, but we want to have a fact-based and a merit-based dialogue. And I think that's what we had today. And that we will have actually tomorrow as well. And I really would like to invite all attendees to the part 2, which starts also at tomorrow, 2 o'clock Amsterdam time. We will have a first panel that will include again a Spanish state lawyer and a representative from the European Commission, who will discuss the toolbox in more detail that states are increasingly using to shape, to reform the system, or as some would say, to rebalance the system, both in terms of procedural, but also in terms of substantive aspects. So that is a really exciting panel. But then last and certainly not least, we have a stunning panel at the end, which will discuss a topic that is often forgotten, but I think also very important for states, is the issue of damages and the issue of calculation of damages and calculation models that are used, and the way tribunals are using various models, and the trend that we see. So I think tomorrow is going to be another really interesting day. So with all that, I want to thank everybody, and also in particular the attendees who stayed until the very end. And thank you so much. And I do hope I see you tomorrow again. Thank you.
Thanks, everyone.
Bye-bye.
Bye.
Thank you. Bye-bye.
Thank you. Bye.